Good morning, everybody. Happy Super Friday. Welcome to TCF Live. I am Dan Soul. I will guide you on a 3-hour journey through Courtlandia. Starting in Michigan, this is Magistrate Urich.
Hold on.
You're fine. While you're
I tried to get the button. It said that I had gone something in the settings, and I've clicked the button. I don't know why it won't open. I really don't know.
Well, you're okay. Stand by for just a minute.
Yes, sir.
You understood the court's instruction for this morning's hearing that you must select from one of three options to protect your own rights, yeah?
Yes, Your Honor.
So you understand that you must therefore either admit and explain or deny responsibility on this expired plates ticket.
Yes, Your Honor.
Citation indicates that on July 15th of this year at 1 minute of 9 o'clock, you were operating a 2025 Ford black in color on 11 Mile Road, near Washington Avenue, City of Royal Oak. At that place in time, it was discovered that your plate had expired about a week before Christmas. So you may admit responsibility, you can admit and explain, or you can deny responsibility and the court will swear the parties and take your testimony. What would you like the court to do for you?
Well, I really didn't know that the plate had expired, so I'm going to accept responsibility with an explanation because
Very well. Okay, let's do that.
I just
fine,
didn't
Mr.
realize that
Blackman.
it expired. Yes, sir.
Hold on for just a second. So you're confirming that on the date in question, you were operating a motor vehicle in Royal Oak with a plate that expired December of 25, yes?
Yes, Your Honor.
All right, your please accepted. Now, you were suggesting you hadn't realized it expired. What else do you want the court to know?
Well, I had gotten the car so late in the year that when the plate was transferred over, foolishly apparently understood that the registration that had transferred over with the car, it was a new lease, had a not just a 2 months, but had another year on it. And I didn't realize it looked the same color. I didn't really look close at it. They're all orange. And so I really never really was aware that this had taken place. I maintained the insurance and everything. So when they brought it to my attention, I went to the Secretary of State and renewed and brought it up. So I do have a copy of the new registration I would like to present.
That's great, but now that leads us to the IT problem of your camera off. Perhaps Officer Bushi consulted the database on this one. Officer?
I did, Your Honor. It's all up to date. As I explained to him, as long as everything was up to date by the court day, I was okay with dismissing.
Thank you very much. That's a motion to dismiss, Mr. Blackmer. So I guess that's Christmas and your birthday all rolled into one.
I love you guys.
Oh, I wouldn't go that far. All right. Good luck to you. Have a great balance of your summer. Bye-bye.
All right. But I still love you guys. Thank you. All right. Take care. God bless.
That's a first for me. Wow. Okay. Calling case number 26, RO 04918. This is People versus Gerald Rashawn Harris. That's you, sir?
Yes, sir.
Good morning, Mr. Harris. You were present earlier when the court explained the nature of an informal hearing. True?
Yes, sir.
So you understood the court's instruction that you must select from one of three options to protect your rights, yes?
Yes, sir.
Thank you, Mr. Harris. This is a relatively simple citation. Indicates that on July the 17th of this year at about 2 minutes of 6 in the morning, you were operating a 2016 Audi white in color on 14 Mile Road, near Coolidge Highway, City of Royal Oak. And at that place in time, you were cited for exceeding the posted speed, which is a posted 40 by a minimum of 6 to a maximum of 10 miles over. Officer Bushi's remark on your radar indicates a rate of speed at 68 and a 40, but he wrote this for 6 to 10 over. So you may admit responsibility, Mr. Harris. You can admit and explain, or you can deny responsibility. The court will swear the parties and conduct your trial. What do you wish the court to do?
Admit and explain.
Very well. So you're confirming to the court that on the date in question, you were operating a motor vehicle in the City of Royal Oak and exceeded the posted speed limit by at least 6 miles over, correct?
Yes, sir.
Thank you. What's happening, Mr. Harris?
Now, I had just came from dropping my daughter off and I was headed to work and I had to be to work by 6 o'clock. And I
Hmm.
work at a soccer recycling facility. So yeah, I was speeding. I was just trying to make it to work.
Okay. Is your dad still alive, Mr. Harris?
Yes.
What would he say?
Get to work on time.
Yeah, he'd say back that alarm clock up about 20 minutes.
Yeah.
So
It's just-
it looks like you were you probably ended up clocking in after 6. So the
yeah.
plan didn't quite work as you intended, but I'm glad your daughter's safe and you're safe and you got employment and life is
I ended
good.
up losing my job. I don't work there no more.
Oh, you're kidding me.
No, I ended up losing. Yeah, I lost my job.
I'm so sorry about that, sir. Thank you for your information, Mr. Harris and Officer Bushi. What would you like to share?
Not too much to add on to it. I will note that he was regrettably sorry about the speeding. I'm okay with dropping it to an impeding.
Very well. There's a motion, Mr. Harris, to amend this to impeding traffic, which is a 0-point violation, will never show on your master driving record. That's acceptable to you?
Yes, sir.
All right. So your original plea to speeding subsumes a plea to impeding. The fine is $175, but given your new circumstances, the court's going to mark that due within 28 days. And the court hopes that the fact of your life turning into a country song here temporarily improves very soon. Okay, so
Okay.
good luck to you.
All right. Thank you very much.
You're welcome.
Oh, wow.
Following case number 26, RO 04669. This is People versus Cashmere, Kimbrough. That's you?
Yes, that is me.
Thank you. Ms. Kimbrough, you were present earlier when the court explained the nature of an informal hearing. True?
Yes, I was.
So you understood the court to instruct that you must select from one of 3 options to protect your rights, yes?
Yes.
Thank you. Ms. Kimbrough, the citation before the court indicates that on July 6th this year at 16 past 10 in the evening, you were operating a 2024 Kia blue in color on Main Street at near 3rd. City Royal Oak. At that place and time, and this is important to distinguish, you were cited for impeding traffic. What Officer Bushi indicates he witnessed in his remarks and captured on video was improper lane usage. So on the roadway, he apparently chose to write this for impeding versus a traffic citation that carries points. Notwithstanding that, Ms. Kimbrough, today is your day in court. You can admit responsibility, you can admit and explain, or you may deny responsibility. The court will swear the parties and take your testimony. What do you wish the court to do for you?
I would like to admit and explain.
Very well. So you're confirming to the court that on the date in question, you were operating a motor vehicle in the city of Royal Oak and in some form impeded traffic, correct?
Yes, correct.
Court accepts your plea. What would you like the court to know?
Well, on that day, I was driving. I was with my best friend. I moved out of Michigan about 3 years ago, and I don't really know my way around like that for real. And I explained that to the officer that I currently live in Arizona now. So my GPS was telling me to go straight, and then it immediately turned, and then it told me to make a right. I think I did signal my blinker. I'm not sure if I didn't, but he said that I had turned from a second lane, and I explained to him like, well, I didn't want to miss my turn. I was driving and I didn't see no other car right there. I did look over. It was not another vehicle over there. And I thought it was safe to turn because I didn't want to miss my turn.
Okay. Ms. Kimbrough, a couple different thoughts. First, The GPS is a great tool. However, minding the signs, the stripes, the signals, and the other motorists is your first order of business. Are you familiar with the phrase "make a box"? So
No, I'm
sometimes
not.
if we're driving and we're looking for a particular location or a street and we see it coming up with some urgency, it's better to go past, come back around, make a box, and come back at it one more time. Otherwise, life can get really complicated. So the court appreciates your explanation. Is there anything the people wish the court to know? Officer.
I've not really anything to add. I already gave her the impeding, so.
Very well. The court's going to assess a fine of $150, Ms. Kimbrough. That is payable through the pay portal on the 44th District Court website, or you may walk a cash check or charge into this court at 400 East 11 Mile Road, Monday through Friday, between 8:30 and 4:30. That's marked due within 14 days. That completes your hearing. Good luck to you.
Wait, where can I pay it? Can I write that down?
Sure. So all you really need to do is go to the Google machine, type in 44th District Court for Michigan. The court's website will come up, and then there is a pay portal called All Paid that is within the court's website.
Okay.
All right.
Okay. Thank you so
Good luck.
much.
Mhm.
You have a
Calling case number 26, RO05398. This is People versus Kelly Michelle Bailey. Miss Bailey, are you available?
Good morning. Yes. How are you?
Good morning, Miss Bailey. You were present earlier when the court explained the nature of an informal hearing, true?
Yes, I was.
So you understood the court's instruction that you must select from one of three options to protect your own rights, yes?
Yes.
Thank you, Miss Bailey. This is a relatively simple citation. It does indicate that on August the 1st of this year at about 9:15, you were operating a 2024 Volvo black in color on Washington Avenue at or near Woodward M1 in the city of Royal Oak. And at that place and time, this is important to note, you were cited for impeding traffic, which is a 0-point violation. What Officer Bushi indicates he witnessed in his remarks on the tickets is drove without headlights, taillights. So rather than writing that more severe ticket, he wrote this for impeding traffic. Regardless, Miss Bailey, today's your day in court. You can admit responsibility, you may admit and explain, or you can deny responsibility, and the court will swear the parties and take your testimony. What do you wish the court to do for you?
I would like to admit and explain.
Very well. So you're confirming to the court that on the date in question, you're operating Volvo motor vehicle in the city of Royal Oak, and in some form or fashion, you impeded traffic, yes?
Yes.
Thank you. The court accepts your plea. What would you like the court to know?
I just wanted to say that I kind of felt like it was his writing a ticket for that was a little bit punitive. I do understand that I was at a stop sign turning left, and I did turn my blinker on. He was not there. He pulled up. There was another car that was in the midst of trying to make a turn, but they weren't sure what they were going to do. And as soon as I turned left, he pulled me over. And my question was, instead of writing the ticket, why wouldn't he ask, do your lights work first? Because my blinker worked. And I also actually stopped to try and let him go, because initially I believe he was going to turn left onto Washington Avenue. I did explain to him immediately when he asked all the questions. I was coming from a restaurant that was right around the corner. I had just pulled out of the parking lot, and I also let him know that I believe I went to the car wash earlier in the day and accidentally hit the button where the automatic lights go on and off. So it was not intentional by all means. It was something that happened in error. So I was just asking that the fine be waived. I do understand what happened, and I totally admitted responsibility. for what took place. But my question was, why didn't he just ask, can you turn your lights on, instead of writing a ticket for it, especially because I don't have any points on my driving record. I have a clean record. And there was no, I didn't give him a hard time about anything. I was very honest about what took place in the moment.
Well, the court will try to unpack this because that's a lot of information. To begin with, driving without lights is a 2-point violation.
Understood.
So that would probably raise your insurance about, I don't know, maybe $750 to $1,000 per 6 months. Secondly, impeding traffic is a 0-point violation, doesn't show on a master driving record. The interesting feature about civil infractions, Ms. Bailey, is they don't require intent. So, for instance, unpacking what you said about he didn't ask me if the lights worked or not. That's really not the question. Say, for instance, you were driving a 1965 jalopy and the lights didn't work. You would still be responsible for the condition of your vehicle. When we're driving a motor vehicle on any public road in the state of Michigan, our vehicle has to be safe for travel. So the court appreciates your remarks. Unless there's anything from the people, officer, the court is ready to impose the sanction.
The only thing I have to add is just part of the reason why we write these tickets, not to solo out your car or anything, but you drive a black car at night, it's almost impossible to see some of those cars without lights on, which is part of the reason why you got the citation. I'm fine with just going ahead and dismissing it. Just make sure you're paying attention to where your knobs are for having your lights on at night. Okay.
Absolutely.
Can't get better than a dismissal, Ms. Bailey. I think, and the officer might, I think I understand what he's suggesting, which is, especially in Royal Oak, it's a grid. It's well lit, and therefore, because it's well lit, folks think, oh, I'm good. And their lights might not be on, but they think they're illuminated. All right.
Yeah.
But when you go from a lit area that might have a commercial cluster or an intersection into a darker area, you or someone else could be severely injured. So this case is dismissed. As the officer says, keep an eye on that knob and good luck to you.
I will. Thank you very much. Appreciate you both.
Admittedly, your host shakes his head. The lady talks about her feels and gets a case dismissed. I don't know. Good for her, I guess, but it says something about us, I think. Happy Super Friday once again, everybody. This is TCF Live. We'll continue with the magistrate here for one or two more, I think, assuming he has one or two more queued up.
Let's make sure, double sure, triple sure. Court calls case number 26 RO 04895. People v. Alfred Bennett Robinson. And 26 RO 04899. People v. Falu Wagney or Wayne. These were both set for 8:31 with Officer Bushi. Officers present. Defendant has not checked in. These will both be marked as failures to appear defaults. And so that gives us a complete flight for you, officer.
Awesome. Thank you, sir.
Have a good one.
You as well.
All right, well, he doesn't have other things queued up at the moment. Good morning once again, everybody. It is TCF Live on a Super Friday, and it is good to have you here. P. Diddy, if I recall correctly, a few days ago, you said, hey, TCF guy, Dan, whatever your name is, how does one go about becoming a panelist on Sidebar? I'm pretty sure that was you. Well, last night on Sidebar, we announced exactly how that happens. We are doing a casting call, my friends. We are looking for people to join the rotation on Sidebar. And in a moment, I will pin in the chat exactly how that's done. We do have an application for you to fill out. It's easy. It's not too hard. But we want people to join us, especially as we go into the fall. We're all busy, so panelists kind of have to move in and out a little bit as other commitments take place, and that show just continues to get bigger and bigger as we approach episode 100 of it already. So I encourage you, if you have any interest at all in joining the conversation, do take a moment and apply to be a panelist on Sidebar. I will pin that in just a moment, but before I do that, let's go over to Judge Elmore. Say good morning to him.
We'll beginning with the Assistant AG.
Good morning, Your Honor. May it please the court, Craig Pappen appearing on behalf of the AG.
Jeff Harrison, I'm here on behalf of Mr. DeShepper. As the court can see, he appears by video and is not in person here today.
Mr. DeShepper, are you able to see and hear the court this morning?
Yes, Your Honor.
All right. So I've always wanted to say this, Mr. Pappen. It does please the court that you're here. Thank you very much. All right. So we're here today for a probation violation hearing. We were last on the record about a month ago for an informal hearing. Was that an informal hearing? Yeah. On the 27th, there was a waiver of the 14-day rule by both parties. This is a question warrant for a probation violation filed back on July 14th. We had an initial arraignment on July 20th. And again, as I said a moment ago, we're back on the record on the 27th. Now we're here. There were two allegations that were raised. Both of them have to do with basically the same alleged misconduct that allegedly occurred on June 30th of this year, involving some abusive behavior upon a child, I think. Basically an allegation of abuse of some degree. And he's currently set for trial, Mr. Harrison.
There is a jury selection in Clinton County in the District Court 62A for the 8th of September. I was unable to secure a firm trial date. Apparently their system's a little bit different than ours. They don't immediately launch into a trial upon selection of the jury. But it would be within that time frame, I suppose.
Thank you. He's currently not in pretrial custody in Clinton County. And I assume, therefore, the defense is requesting to adjourn the formal hearing today.
Yes, that's simply put. I think it makes a lot of sense just to simply, I hate kicking the can down the road. The inevitability factor kicks in, but I think it makes sense here depending on the outcome of that trial.
The court recognizes that Court Rule 6.445 allows the court to either conduct a hearing or adjourn it pending the resolution of the new criminal case in the other county. How is he, Mr. Pappen, do you know how he's doing on paying his child support?
Yes, Your Honor. That appears that he's complying with the order. We see a current arrearage as low as now $301.25. That's considerable progress since this has been on probation.
All right. I'm inclined to, unless I have an objection from the people, is to adjourn it, allow him to continue making payments while I recognize there's new criminal misconduct alleged that really, because this is a case involving a failure to pay child support, I would guess, or I'm sorry, I take the position that our file is all about helping getting child support paid. I'm more than willing to adjourn it based upon what I think is good cause. Mr. Pappen, does the people, or do the people have any objections?
No, Your Honor, we do not.
The court again finds pursuant to Court Rule 6.445 that there is good cause and that the court will allow the court to do so, and the court therefore grants the adjournment. One moment here. Oh, the court recognizes Mr. Brian Potter here today on behalf of the Department of Corrections, serving as today's probation officer here in the file. One moment. Mr. Harrison, you said, what was that date, September?
8. I will keep you posted in terms of the trial date or any resolution of the case, because there's no point in leaving this one floating in the air. And that may make a difference to the AG if he's able to satisfy his obligation compared to the arrearage of the interim as well. So I think there's a number of possible outcomes here.
I'm going to have my staff set it out on 3 weeks into September. If Mr. Harrison, you find that the trial in the other county is posted after that date, we don't need to have everybody appear. I'll just adjourn it until afterwards. All right, thank you.
Sincerely appreciate that accommodation. Thank you, Mr. Papin.
Thank you.
Thank you, Mr. Papin. Anything else, sir, on behalf of the people?
Your Honor, just the new date. I'm sorry, I didn't catch that.
I don't give the new dates. I don't cross my staff's lane. Otherwise, they'll get upset and hit me.
I understand.
They've done it before.
But anyways, no, we'll get it probably about somewhere in the 3rd week. Mr. Shepherd, have you been able to continuously see and hear us today?
Do what?
Have you been able to see and hear us today?
Yes.
Right. And you agree to waiving this, continue to waive and adjourn this hearing out?
Yes.
Thank you. All right.
I do have
one
one question though about the no contact order.
This is a child. He's a stepchild. Obviously, he's returning to school. He's 14 now.
Is it the stepchild? I'm sorry.
The alleged victim. Yeah. And interestingly enough, there is no similar order, companion order, imposed by the court in Clinton County.
Really?
Yeah.
Oh, yes, Mr. Potter.
I ran lien today, Your Honor, and there was a protected victim in lien for a no contact order.
For the 62A case?
I just saw that there was I just assumed it was that case. That it was
I
a bond condition of no contact.
Yeah, he imposed.
I imposed one.
Is that what it was? Okay, I just saw that in lien when I ran it. So.
All right, so.
These people are a family, Your Honor, and it would make
really odd. I don't know why another court would not give a bond order.
In my conversation with Mr. Shepherd, I was assuming that they had.
Yeah.
When he first broached the issue, I said, well, it doesn't make much difference what we do here.
All right. Now, Mr. Papin, if I were to remove my no contact order, if there truly is one out of Clinton County, then obviously what I do won't have any impact. If there isn't one out of the county for which the charge is actually filed, then it would be up.
Right. Your Honor, I'd largely leave it in your discretion, but I would point out, though, that our interest, of course, is that the child support gets paid. If the allegations prove to be true, that can interfere with the payment of child support with new criminal behavior and any incarceration or other problems that can arise from that. So we are concerned about that aspect of it. The child that has the protective order is the victim in the underlying case, and I would not like to see any undue influence in that respect.
The Register of Actions for the case in Clinton County says no contact with victim.
Okay.
All right.
Once and for all, then. Thank you for looking that up.
Wow, man.
So it's essentially moot here as well.
Yeah.
So.
All right. In my exacerbation is because apparently we have improved computer capabilities.
If it comes to be lifted in Clinton County, I will advise the court accordingly.
All right. The court will leave it as already set by this court. If there's a modification or dismissal or whatever in the other county, just let me know, Mr. Harrison.
I will.
All right. Thank you all very much for the time. We're adjourned.
Thank you.
Thank you, Your Honor.
Thank you.
Half an hour in now to TCF Live on the Super Friday. Speaking of Super Fridays, Ashley, a $10 super chat. Thank you for that. She says, make it a great day or not, the choice is yours. Good words of wisdom. Thank you, Ashley. And Austin celebrates 1 year as a channel member. Says, I can't imagine not being in the TCF family. Well, I'll be honest with you, Austin, the TCF family cannot imagine you not being with us. your full-throated support of this community and of me. Everything you do for us, from research to being on sidebar to just being present every day, never goes unnoticed. So thank you, my friend. I appreciate you giving us this past year, and I look forward to another year with you here with us at the channel and getting to know you even better. Alrighty, let's go back to the magistrate. It looks like he's got a new set of contestants.
OS 17124. This is People versus Sean Fletcher Foreman. That's you, sir?
Yes, sir.
Good morning, Mr. Foreman. You were present paying attention just seconds ago when the court explained the nature of an informal hearing. True?
Yes.
So you also understood the court to instruct that you must select from one of three options to protect your own rights. Yes?
Yes.
Thank you very much. This is a documentary 0-point non-moving violation. Mr. Foreman, it does indicate that on June the 19th of this year at about 20 past noon, you were operating a 2025 Hyundai, white in color, on Woodward Avenue, M1, near Ravenna, in the city of Royal Oak. And at that place and time, you were found to be unable to produce a valid and current proof of insurance to the deputy at his request. The court does note that there appears to be a proof of insurance within the file, but the court first has to establish the status of the insurance as to June 19th. So you have your three options. You may admit responsibility, you may admit and explain, or you can deny responsibility, and the court will swear the parties and take your testimony. What do you wish the court to do for you?
I'll take the second option. I have the document here.
Very well. So you're confirming to the court that on the being question, you were operating a motor vehicle in the. Let's get this completely straight. On Woodward at Ravenna in the city of Royal Oak, and you were unable to produce a valid proof of insurance at the officer's request, correct?
Correct. I had an electronic copy that
Okay.
at the time. Yeah, at the time I just couldn't get it
So
on
you
the
want
phone.
you want the court to take judicial notice of this proof of insurance that you apparently mailed to the court, correct?
Yes.
All
I
right.
have the
That
same.
shows an expiration of November 1 of 2026.
Correct.
Okay. Thank you, Mr. Foreman. And Deputy, what would you like to share?
Your Honor, as long as he renewed it or he had the proof, I'm good with dismissing it.
Very well. You don't have a problem with the dismissal, do you, Mr. Fletcher?
I do not.
Okay. This matter is dismissed. Everything's A-OK on Rensselaer?
Yes.
All right.
So far.
It's the most mispronounced street name in the entire county.
That's the way I pronounce it as well. Yeah.
Okay. Be well, sir.
All right. Thank you, guys.
Calling case number 26, OS 21282. People versus Aileen Maya Raymond. That's you?
Yes, that's me.
Good morning, Miss Raymond. You were present earlier when the court explained the nature of an informal hearing. True?
Yes.
So you understood the court to instruct that you must select from one of three options to protect your own rights. Yes?
Yes.
Thank you, Miss Raymond. The citation before the court was issued on July 28 this year at exactly 2 p.m. You were operating a 2026 Chrysler Pacifica, white in color, on Crooks Road, near Lloyd, in the city of Royal Oak. And at that place and time, you were cited for speeding a minimum of 1 to a maximum of 5 miles over the speed limit. Deputy's remark that shows on your ticket indicates a margin of speed of 45 and a 30, but apparently he chose to exercise his discretion and write this for 1 to 5 over. And it is suggested that this was what they refer to as a LiDAR reading. So the speed was measured by laser radar at a distance of 408 feet. So you may, at your option, admit responsibility, you can admit and explain, or you may deny responsibility. The court will swear the parties to take your testimony. What do you wish the court to do for you?
Admit and explain.
Very well. So you're confirming to the court that on the date in question, you were operating a motor vehicle in the city of Royal Oak and exceeded the posted speed by at least 1 mile, correct?
Correct.
Thank you. What would you like to tell the court, Ms. Raymond?
I admit responsibility. I was speeding. My daughter had broken her foot and I was on my way to a doctor's appointment for her. So I actually would just like to ask the court if perhaps I could request a violation without points.
Was this a fresh break or was this a follow-up?
It was a fresh break. We had gone to urgent care the day prior. And I wanted to take her to an orthopedist because they said she had broken her big toe and it could affect the way she walks because they put her in a boot initially. Okay. So I had gotten an orthopedist appointment that day at the last minute and I was trying to get her to it before the time. We were running a little behind and I was admittedly a little frazzled. So
Fair enough.
Yeah.
Thank you. Ms. Raymond, what the court does need to let you know is the court doesn't have the statutory authority to add or subtract points. That's the province of the Secretary of State and or subject to any motion practice by the people. But for our purposes, Deputy, what would you like to share related to Ms. Raymond and her daughter and the big toe?
Well, I can speak about Miss Raymond. I don't know about the big toe. But for Miss Raymond, I don't mind amending it to a impeding traffic as a one-time courtesy. But other than that she needs to slow down.
Okay. Impeding traffic, Miss Raymond, will get you where you appear to want to be. That is a 0-point violation, will not appear on your master driving record. Acceptable, yes?
Yes, that's acceptable.
Thank you very much. Your original plea subsumes a plea to impeding traffic. The fine is $175 payable through the pay portal on the court's website, or you can walk a cash check or charge into this court at 400 East 11 Mile Road, Monday through Friday between 8:30 and 4:30. That's marked due within 14 days. Good luck to you.
Thank you so much. Have a good day.
No, Berkeley hasn't lit up yet.
Oh, he's in the breakout.
Oh, okay. I got a custody I have to run between the blockers here with Dep. Just one moment.
Okay.
And I guess he's done. Give me just 1 second. I was in the middle of queuing up the next thing when he decided to stop his stream. So give me 1 second while I get that queued up, because he was just too doggone fast. Okay, here we go. Florida, Wade Mercer.
Please, we do have some friends or family in the courtroom, so let me take those cases first. The first one on our list that has friends or family here is Roselle Daniels. Mr. Daniels, good morning. Mr. Daniels, you're here in Jackson County case 20-165CT. Mr. Daniels, you're accused of driving a commercial motor vehicle while your driver's license was suspended, revoked, or canceled. Mr. Daniels, this warrant's been out for you for over 6 years. You do have your sister and your wife are both in the courtroom. Mr. Daniels, I'm appointing the public defender's office to represent you for first appearance purposes. Please listen to Mr. McDaniel.
Your Honor, just to let you know, we probably would just take care of this case out of simplicity because he was arrested in Hillsborough County, got transferred up here. However, he's a truck driver, and you know his license, if he pleads to this case, they'll be revoked for a long period of time. So at this point in time, we just asked the court to consider some kind of bond. He's got his valid commercial driver's license. I don't know if it was done by mistake or, you know, I'm not quite sure. I haven't had time to look at it, but I know he does have his commercial driver's license and he's never stopped driving. He's been driving. So we just asked the court maybe to consider some kind of bond so he can get out and try to talk to an attorney. Try to figure this out.
Mr. McDaniel, is it your position he's entitled to a bond?
Yes, Your Honor.
This is back when we set no bond on cases, and then you provided some case law that showed that they were actually entitled to bonds in this particular type of case where they were sent a notice to appear and didn't appear, but they were never arrested, never on bond, never on pretrial release, weren't on probation. Is that right?
Right.
Mr. Gill, do you agree Mr. Daniels is entitled to a bond?
Judge, I have not seen that case law. I will probably agree with Mr. McDaniel. He's correct on that. We'll defer to the court.
Yeah, basically it was the misdemeanor cases where there's a warrant issued for failure to appear and you don't have evidence that they received the notice, can't prove they received it. So what we started doing probably 2 or 3 years ago, Mr. McDaniel, we started setting bonds in those type cases. However, if they were given a handwritten notice or if they had already posted bond, that was different. Mr. Daniels, there are notes in the system saying you've known about this and communicated with someone in my office since 2020 and still haven't resolved this case. Therefore, I'm going to set your bond in this case at $10,000. I do consider you a flight risk because it appears you've known about it and haven't dealt with it. But I think you're entitled to a bond. You haven't dealt with it in 6 years. So your bond's $10,000 cash or surety. If Mr. McDaniel and Mr. Gill work out some kind of agreement to amend the charge to something else, then that's fine. I have no problem with a resolution, but I am concerned that you're not going to show up back to court because it appears you haven't shown up for court for 6 years when you've known about it. But you've got the right to post bond in its cash or surety. You can go through a bondsman. Mr. McDaniel, are you requesting a cash bond knowing the bond I'm going to set?
Can I get my?
That's a VOP warrant. So she needs to make arrangements for that child. Go ahead and make arrangements. I mean, I'll still see it, but it's a VOP.
He would request a cash bond.
Okay, Mr. Gill, any objection to a cash bond?
No, based on the nature of the charges.
Okay, Mr. Daniels, that means your cash bond will be $1,000 cash. So ladies, the reason the bond's a little higher than normal, but it appears that he's known about this for years and hasn't dealt with it. And then he got arrested in Hillsborough County. So if he had turned himself in here, that'd obviously be something, a factor. None of those things happened. That's why the bond is what it is. Do you have any questions, ladies? Sure, sure.
Respectfully, it was during 2020 at the height of COVID. We have the information where Stephanie, someone with the courts asked for the information saying that he had a CDL. We faxed that on May 5th, 2020. I have the original fax and the email correspondence from the court.
Do you know why he hasn't turned himself in since 2020 to get this issue resolved or even come to court down here to try to get it resolved? You have an answer for that?
The last email that we sent was asking for a court date. We didn't receive an additional email. So we thought once we sent this information, we had resolved it. We would never, my mom, he took my mom to Emory. She had cancer. She had to have treatment that day. Otherwise, he would have been in court. But once we sent that information.
So you never heard anything back, one way or the other. So you just assumed everything had been resolved.
And I know we should.
That's not very believable, ma'am. I'm not going to accept that. His bond is set at that amount. He's known about this for years. He's refused to deal with it. So now he's got to deal with it. Okay. Thank you, ladies. Mr. Daniels, do you have any questions?
Can I get my props? Can I get, he asked me.
Court date will be when?
No questions, Your Honor. Thank you.
Your court date will be September 28th at 9 o'clock. And the jail will give you that notice unless it's dismissed before then. If you get that documentation at the state, I don't know what they'll do. That's Mr. Gill's, someone in his office will make that call. Okay. Thank y'all for coming. Next person that has friends or family here is Ticoria Holden.
Who did you call, Your Honor?
Miss Holden. Miss Holden, good morning. Miss Holden, you're here for first appearance accused of one count of driving while license suspended or revoked knowingly. Miss Holden, there is probable cause in the complaint. Looking at your driving record, it appears this is your third charge of this. Miss Holden, I'm appointing the public defender's office to represent you for first appearance purposes. Please listen to Mr. McDaniel, and then we'll see where we go from there. And your mother's in the courtroom. I'm not sure if I said that or not. Mr. McDaniel? I think you're muted still.
We'd ask for a reasonable bond, Your Honor.
Mr. Gill.
Defer to the court, Your Honor.
Ms. Holden, I'm gonna set your normal bond. I set for a misdemeanor charge like this, ma'am. Your bond's $2,500 cash or surety. Cash or surety means you can go through a bondsman. You don't have to come up with all $2,500, ma'am. If you go through a bondsman, they're going to charge you somewhere around $250, ma'am. You do have a condition not to drive a motor vehicle without a valid license. Ms. Holden, if you get your license straightened out, you can drive all you want. But if you get caught driving without a license again, that could and would most likely violate your bond, ma'am. And you'd be held with no bond. So the jail's going to give you a court notice for your court date. That'll be September 28th at 9 a.m. You will not get a notice in the mail. They'll put that notice in your hand in just a few minutes, and you'll use the phone to try to post the bond. Let me see if your mother has any questions. Ma'am, do you have any questions? I can't hear you. So I know she can't hear you. So come on up, please. I want to make sure she can hear you, and obviously I need to hear you too. Yes, ma'am. Well, there's two ways to do it. If you have the 2,500 and you want to post the whole thing, you don't have to go through a bail bondsman. If you decide to go through a bail bondsman, you contact the bail bondsman. And Florida law says they charge you basically 10% of the bond. So that's $250. Whatever bail bondsman you choose that operates in Jackson County, and then they can post bond for. Any other questions? Yes, ma'am. Have a good day. Have a good day. Ms. Holden, you have any questions? No. All right. Take care, ma'am. The next person that has friends or family here would be Alan McGurran. McGurran, good morning. Your mother is here. Mr. McGurran, you're here because you've been accused of violating the terms of your state supervision. I've got a copy of the warrant in front of me signed by the circuit judge, and it has no bond on it. Mr. McGurran, what I'm going to do is get you arraigned this morning because you've got a VOP, and now that there's an affidavit filed, I can go ahead and arraign you. Arraigning you means appointing you a lawyer if you wish for me to do so, and in telling you what you're accused of, which I've already done. Mr. McGurran, would you like to have an attorney appointed to represent you?
Yes, sir.
I'm going to appoint the public defender's office to represent you. Please listen to Mr. McDaniel. We'll see if you have any questions in just a minute.
Your Honor, we interplead not guilty. Asked to set this on the October 8th court docket, and I advise him someone to come by and speak to him prior to that hearing.
October 8th. Thank you, Mr. Gill. Anything?
Nothing from the state.
So, Mr. McGurran, October 8th is your court date. Attorney will see you before your court date or on your court date. Do you have any questions?
Does the days I have in Bay County count as credit?
If you go to prison, it does.
Ma'am, do you have any questions? Any questions, ma'am? So he's got, the judge in his case has set no bond, and his court date's October 8th. Yes, ma'am, in the Jackson County case. He's got no bond right now because it's a violation of probation charge. Okay, thank you. I also have friends or family here, and is it Soraya? Am I saying that right? Soraya Spears? October 8th. Yes, ma'am. We're going to be in the next courtroom down. Ms. Spears, good morning. Ms. Spears, you're here because you've been accused of one count of driving while license suspended or revoked knowingly. Your grandparents are both here. Ms. Spears, I'm going to appoint the public defender's office to represent you and ask that you listen to Mr. McDaniel.
Your Honor, I spoke to Ms. Spears. She's going to plead no contest. The charges listed. The understanding she will be placed on probation for 6 months, be a $400 fine. She early terminated. She gets everything done. I don't think she can get if she gets a valid license, it'd be $300. I don't know if she can get a hardship or not. I don't think she's able to now that she's got discharged. That'll resolve this case.
Thank you. Mr. Gill, is that agreeable with the state?
It is, Your Honor.
Ms. Spears, did you hear that agreement?
Yes.
Ms. Spears, do you have any questions about that agreement?
No.
And Ms. Spears, is this the plea you would like to enter? Is this what you want to do?
Yes.
Ms. Spears, I'm going to accept your plea of no contest to the charge of driving while license suspended or revoked knowingly, ma'am. Withhold adjudication of guilt and issue to 6 months probation. Court costs and fines of $400 are imposed. Ms. Spears, you have a condition to obtain a valid driver's license if one is reasonably available to you. What that means is some people can't get a license either because it's so expensive or for other reasons. If you can't, you can't. But if you just only got to pay a ticket or something like that, you're going to be expected to get a license. Ms. Spears, you're going to have a condition not to drive a motor vehicle unless you have a valid license. If you get a license, you drive all you want. And Ms. Spears, you may get off probation early by doing half the probation, ma'am, getting everything resolved, having no violations. Ms. Spears, do you have any questions?
No.
Any questions?
No.
So to her grandparents, what'll happen now is they'll process her out, which means that they'll let her use the phone if she wishes, let her get dressed in her regular clothes. Then they'll bring her to the probation office. Probation office is downstairs inside the county judge's office. When they get here, she'll meet with the probation officer. That only takes 5 or 10 minutes. They'll go over the probation with her. They'll give her a copy of all the rules in writing. They'll give her a chance to ask any questions, and then she'll be free to go. So usually that's 30 to 45 minutes from when first appearance ends. She'll be downstairs. Is someone going to be able to pick her up? Or one of you going to be able to pick her up? So your family says someone will be here to pick you up. You don't have to worry about transportation. Ms. Spears, do you have any questions?
No, sir.
Y'all have any questions? No? All right. Thank y'all for coming. Wish you the best, Ms. Spears. We have Daryl Johnson. We've got another one that has friends or family here, Mr. McDaniel. The very last case on the docket. Mr. Johnson, good morning. Mr. Johnson, your father is here this morning. Looks like I first appeared you on a new charge and you had a hold out of Leon County, where I placed a 7-day hold on you to see what Leon County was going to do. And Mr. McDaniel sent us a copy of some paperwork this morning. Leon County issued a warrant, but it looks like it's not for violation, revocation of bond. It's for allegedly missing a court date while he was in jail. Is that right, Mr. McDaniel?
Correct.
And there's a bond on it of a total of $6,000? Correct. Okay. So here's what that means. You've got a bond from Leon County of $6,000. You've got a bond in Jackson County that was set at $10,000. Your total bond between the two counties is $16,000. If you post bond in Jackson County and want to go to Leon, I'm going to ask the jail to send you paperwork with you to show that you were in jail when you missed the court date. The problem is when they get that over there and they see that, if they're not aware of the charge already, they're going to become aware that you got a new charge here. Just because they haven't revoked your bond yet doesn't mean they can't. It simply means they haven't done it yet. So you've got those two bonds. What you do is up to you. If you don't post a bond, you'll stay and deal with the charges here first. If you do post a bond here, you will go to Leon County. If you post both bonds, you'll be released. So let me see if your dad has any questions. You have any questions, sir? What would be the post both bonds? If you post both bonds, $16,000, and you go through a bondsman, that would be $1,600. Here would be my concern if I were the father. My concern would be you do that, and then Leon County revokes his bond because he got a new charge while he was out on bond. And he goes to jail in Leon County with no bond. Then you just wasted $1,600. But that's so what I would suggest is you may want to talk to somebody, attorney or somebody in Leon County first before you do that, because you don't want to post bond, get him out, and then have him revoke his bond. That's why we held him 10 days to give them time to do that. They did not do it, and they may not. I don't know that they will, but you need to be aware of that possibility. Okay. So does he have an attorney in Leon County? Yes, sir. You may want to talk to that attorney before you do anything.
I have talked to him. That's what they're working on.
Okay.
Like terminology wrong, but stated.
And that's what he's trying to do, or he or she is probably trying to do, is trying to avoid what I just described. They're trying to deal with that before he posts bond here. That's probably what they're doing. Okay. So your dad's working on it, Mr. Johnson, and you've got the right to post the bonds. If you do, you'll be released, but there is the possible downside of the unknown with Leon County right now. Mr. Johnson at the jail, do you have any questions? In the courtroom, sir, do you have any questions? All right, thank you for coming. Wish you the best, Mr. Johnson. All right, so that's it for friends or family in the courtroom, Mr. McDaniel. We have, let me see, we've got Kimberly Boykin Ward, Jackson County case. Miss Boykin Ward, good morning, ma'am. You're here because you've been accused of one count of public assistance fraud. Miss Boykin Ward, I have read the complaint, ma'am. I'm going to appoint the public defender's officer to represent you for first appearance purposes. Please listen to Mr. McDaniel.
Your Honor, we just asked for, some kind of reasonable release option if the court finds probable cause, and maybe, I don't know. I know she don't have much money, so I don't know what her criminal history is, but maybe it's some kind of cash bond if the court can. I don't even know if she can pay that, but
So are you contesting probable cause or not, Mr. McDaniel?
I can't see anything on the case, so I don't know what's in the case, so,
Okay. Because it's warrant status, it won't let you see it.
correct.
Let me deal with that issue first then. So Mr. McDaniel. This is a public assistance fraud case. The state has filed formal charges for public assistance fraud based upon an affidavit complaint sent by the state agency that does that. I'm not sure if it's Department of Business Professional Regulation or what agency it is. I'll find out in just a second. But here's my concern, Mr. McDaniel and Mr. Gill. Florida Department of Financial Services. What it says is that Ms. Boykin Ward allegedly received payments, Medicaid benefit payments, while listing her granddaughter as a member of the household. And they believe that the granddaughter was not a member of the household because what it says is it was revealed that the granddaughter resided with her mother in the state of Kansas during the time period. So Kimberly Boykin Ward falsely reported the granddaughter as a member of her household. What it doesn't tell me at all is what leads into that conclusion. Are they simply saying that two people listed the granddaughter as a member of the household and therefore one of them is lying? That's logical, but which one? And the complaint never says what their basis to reach that conclusion is. That was the question I had. Mr. Gill, what's your input, sir?
Judge, I've read the four corners of the document. Ultimately, these cases are most of the time document heavy in the sense that there's an application that she has to sign under oath claiming that the granddaughter was living with her and that she was entitled to the benefits of that. And the allegations in the four corners said that she was not in, I think it was out of state somewhere, maybe. So she was not entitled to this. I get that it doesn't list a lot of details as to how that played out. It does give us a time frame of when she was, applying for the applications and the benefits, and then when that granddaughter was allegedly out of state. So it lists the granddaughter. I mean, obviously the granddaughter could testify, yeah, I was living out here for that time period, but you're right. The four corners is bare bones. I would submit that there is probable cause.
Yeah, I have no idea what leads to that conclusion. For all I know, your daughter was lying about the child living with you. I don't know where they're getting this information from. It's not even close calling for probable cause in my mind. There's no probable cause for this charge, ma'am. You got to have more than that. You got to have the basis for why you reached the conclusion you reached, not just the conclusion you reached. There's no probable cause. You're going to be released on this charge. This does not mean that law enforcement can't, the state attorney's office may be able to fix this by simply getting an amended complaint showing why they believe the granddaughter was out of state. I don't know the age of the granddaughter. I don't know that it tells us in here. So I don't know if she could be a witness. I don't know if there's school records, medical records. I have no idea what leads them to this conclusion. That's kind of the whole point. They don't tell us anything in this complaint that amounts to probable cause. You're going to be released this morning, ma'am. Make sure the clerk of court has a good mailing address for you, ma'am, so that you can come to court. I don't want you to miss your court date, Ms. Boykin Ward. Do you have any questions, ma'am?
No, sir, but I'm willing to come down and let them know the dates and everything. I can give them.
Yeah. Talk to an attorney in private about any defenses you may have, but make sure the clerk has a good address for you, okay?
What's the court date, Your Honor? Or is she going to be going to the arraignment docket?
Mr. Gill, do you want to put on an arraignment docket to just kind of see where things stand?
Arraigned on the formal charges by the state.
Well, she can't be arraigned when there's no probable cause. She cannot be arraigned until y'all fix it, because I found no probable cause at first appearance. So y'all got to file there's got to be some additional information docketed before she can be arraigned. I know y'all filed charges, but filing charges doesn't establish probable cause. The state can't establish probable cause, only the judge can.
So I guess just put her on the next arraignment
For
document.
tracking purposes and let y'all see where you stand by then?
Yeah.
What would that be?
November 6th?
October 6th. So Ms. Boykin Ward, they're going to give you a notice for October 6th. So you'll get the notice. So you don't have to, it's not as important that they have a good address for you. That still would be helpful for future dates, but they're going to put this notice in your hand for October 6th. And by that point on October 6th, the state will have a chance to talk to the investigator and say, can you further explain in this complaint or in an amended complaint why these allegations are coming forward, and then Judge Garcia can review it and make a finding of probable cause or not. prior to the arraignment. Any questions, ma'am?
No,
All right,
sir.
have a good day, ma'am.
Thank you.
Yes, ma'am. We have David Albright. Albright, good morning. Mr. Albright, you're here because you've been accused of one count of aggravated battery in case 26304 CF, one count of battery in that same case number. I've already found probable cause because I'm the judge that signed the warrant on those particular cases. In addition to that, you have a violation of county probation in case 26101 CT. So let me deal with the violation of county probation first and see if we can resolve it, and then we'll set a bond on the other cases. Mr. McDaniel.
Your Honor, Mr. Albright's going to admit that he violated his probation, understanding 60 days in the county jail, 10 days jail credit, remaining fine will be imposed, and that'll resolve this case today.
$400 is left. Mr. Gill, is that agreeable with the state?
As to the violation of county probation, yes, Your Honor.
Any input on the bond on the other cases, Mr. Gill?
As far as the bond analysis, Judge, I believe he's entitled to a bond. I know that he just pled to probation in Holmes County case 26 CF 250. We're just asking that he have no contact with the alleged victim, who is Joshua Barnes. And we're asking for a reasonable bond.
Thank you.
He's got a bars to bed, Your Honor, so he can't go nowhere. He's got sentenced to bars to bed. Bed to
Okay,
bars.
thank you. And that's in the Holmes County case, right?
Correct.
Okay, thank you. So, Mr. Albright, I'm going to accept, is that the plea you want to enter in the VOP first, in the county, Jackson County violation of probation?
Yes, sir.
So in that charge, I'm going to accept your admission that you violated your probation in case 26-101 CT, revoke that probation, sentence you to 60 days in jail, give you credit for 10 days you've already served, $400 court costs and fines remaining. The new aggravated battery bond is going to be $25,000. The new battery bond, felony battery, that is, will be $10,000. Your bond on the new Jackson County charges is $35,000. Cash or surety, you do have a condition of no contact with the alleged victim. As Mr. McDaniel mentioned, you've already got a detainer or you've got a hold to go to an inpatient drug treatment program. So we'll see what happens when you get through with your sentence. You may or may not have resolved the felonies by then, but we'll get you over to felony court at the next arraignment date, and you'll get attorney appointed if you request one and if you qualify for one. Mr. Albright, do you have any questions?
Yes, sir. What day did you say that arraignment date was?
Thank you for reminding me of that. Your court date should be October 6th, at 9 a.m. and they'll give you that notice in just a minute, sir.
Yes, sir.
Have a good day. We have Matthew Collins next. Mr. Collins, good morning. Mr. Collins, you're here for 6 counts of felony petty theft. I'm the judge that signed the warrant in this case. I've already reviewed the complaint. There is probable cause. In addition to that, I've looked at your criminal history, which is very lengthy, including many prior theft-related charges. We're going to see what the attorney's position is, and then we're going to address your bond status. Mr. McDaniel, anything on behalf of Mr. Collins?
Nothing, Your Honor. We just asked for a reasonable bond.
Thank you, Mr. Gill.
Judge, we're just asking for a reasonable bond. He have no contact with Walmart and Lowe's.
Thank you. Mr. Collins, your bond's going to be $10,000 on each of these cases because of your criminal history is so bad and because you have so many charges pending in other places. So your total bond is $60,000 cash or surety. Mr. Collins, you have a condition to have no contact with any Walmart at all while the case is pending. If you post the bond, you'll be released. If you don't post the bond, Mr. Collins, then what will happen is the jail will get you to your court date. Your court date will be October 6th at 9 a.m. in front of Judge Garcia. Mr. Collins, do you have any questions?
No, sir.
Wish you the best, Mr. Collins.
Judge, that also includes Lowe's, correct?
Was Lowe's was one of these Lowe's?
One case was Lowe's and one case was Walmart.
Let me clarify that, Mr. Collins. No contact with Walmart or Lowe's. My mistake. Thank you.
Oh, I got a question for you.
And after Mr. Collins, we have Ricky Stewart. Ms. Stewart, good morning. You're here in case 25-450 CT. You're accused of failure to appear on a driving while license suspended or revoked case, ma'am. Warrant's been out in your case since September of 25. I'm going to appoint the public defender's officer to represent you, ma'am. I'm going to ask that you listen to Mr. McDaniel.
Your Honor, I told Ms. Stewart she's been pleaded no contest and charges listed. The understanding should be sentenced to 10 days in the county jail, credit for 10 days. There'll be a $400 fine. I advised her that she's got, I believe, 60 days to pay that fine, or they're gonna suspend her license again. She did get them fixed at the court, and, she has valid license. I'm not quite sure how she got them fixed with a warrant out there, but she got them fixed somehow. But, so that's all we have, Your Honor. She has signed a plea waiver form, waiving right to jury trial and call witnesses.
Tell me about the 10 days credit. That she may have had some on the front end, but I didn't see but about 6 days recently.
15 on the front end, 5 on the back end, 6 on the back end. So she's got 21 days credit.
Mr. Gill.
That is agreeable to state, Your Honor.
Ms. Stewart, did you hear that agreement?
Yes, sir.
Ms. Stewart, do you have any questions about that agreement?
No, sir.
And is that the plea you would like to enter, ma'am?
Yes, sir.
Ms. Stewart, I'm going to accept your plea of no contest to the charge of driving while license suspended or revoked. Case number 25-450 CT. I'm going to judge you guilty of that offense. I'm going to sentence you to 10 days in Jackson County Jail, but you have credit for more than 10 days because of the hold in your prior credit, ma'am. So essentially, it's a time served sentence. I am going to impose the court costs and fines. They're $400. Ma'am, they'll become a civil judgment, as Mr. McDaniel said, if you don't pay them within the time set by state law. And Ms. Stewart, you're going to be released today as long as you don't have any holds anywhere. The jail will do a warrants check, make sure you're not wanted anywhere. As long as you're not, you'll be released today. Do you have any questions?
No, sir. Thank you, sir.
Yes, ma'am. Wish you the best.
Thank you. Thank you.
We have Ralph Green. Mr. Green, good morning. Mr. Green, you're here for first appearance accused of 1 count of child abuse without great bodily harm and additional charge of battery. Mr. Green, I'm going to appoint the public defender's office to represent you. I have read the complaint. It appears you have no criminal history at all, Mr. Green. Is that accurate?
Yes, sir.
Mr. Green, listen to the attorneys and then we'll see where we go. Mr. McDaniel.
We just asked for some kind of reasonable release option, maybe a conditional release or cash bond. He is locally, lives in the area, he's retired. We just asked the court to consider those options.
Mr. Gill.
If we're asking for a reasonable bond, you have no contact with JWM.
Okay, so Mr. Green, reading the complaint, I think there's enough there for probable cause. I feel comfortable making that decision, but I will say it's not your typical charge of child abuse. The injuries appear to be from the complaint based upon a scuffle that you and the grandchild allegedly got into, stepchild or grandchild, I can't remember, but it wasn't like your typical child abuse case we see from discipline. My concern is the contact. So, Mr. Green, the young man that's the alleged victim, do you live in the same home with that young man?
No, sir. No, sir.
So having, what is your legal relationship to him?
He's I'm married his grandmother, so I'm his step grandparent.
So an order of no contact with that child is not going to be an undue burden on you because you don't live in the same home, correct?
No, not at all.
So, Mr. Gill, with this complaint, with the lack of history, I'm considering a conditional release. Mr. Gill, anything from the state?
Nothing from the state, Your Honor.
Mr. Green, I'm going to let you pick between a bond and a conditional release because of the complaint as well as because of your lack of history as a primary factor. If you want to post a bond, you can do that. Some people prefer a bond. Your bond will be $5,000 cash or surety because it's a third-degree felony. If you want to accept the conditional release, I am going to offer you a conditional release with the standard conditions of release. Either way, there's going to be a condition of no contact with the alleged victim, in addition to any other standard conditions. So, Mr. Green, do you understand your choice between the bond and the release, sir?
I'll take the release.
Okay, let me clarify. Thank you. Ms. Williams just pointed out to me there's 2 charges. So it actually be $5,000 plus $2,500. So it's a $7,500 bond, but you still get the conditional release option. And he wants to choose the conditional release. So what's going to happen, Mr. Green? I'm sorry. Go ahead, Mr. McDaniel.
Would you consider a cash bond?
Mr. Gill, what's the state's position on the cash? Well, let me ask a question before we get to that. I had a question about, in this fact pattern, can the state charge battery and child abuse for the same alleged criminal act? Because it affects whether it's 1 bond or 2.
I'm not up to date on the case law. I've read it before. I think that there are problems with a simple battery. There's loco parentis and all that kind of thing that play into that. It's an analysis.
So let me do this then. Out of abundance of caution, the bond's going to be $5,000 on the child abuse and an ROR on the battery, because I'm not convinced, and Mr. Gill obviously has the same concerns I have, that they can charge you with that for 1 criminal episode, charge you with both crimes. So it's a $5,000 bond. Having said that, what's the state's position on the cash bond request, Mr. Gill?
No objection to cash bond.
I don't have a problem with it when the state and defense are in agreement. So your cash bond is $500. You still have the condition of no contact with the alleged victim, $500 cash bond. Any questions, Mr. Green?
No, sir.
All right, sir. We'll ask the jail to give you a notice for your court date. Should be October 6th at 9 a.m. in front of Judge Garcia. 8:30, 9 a.m. at 8, October 6th at 8:30 a.m. in front of Judge Garcia, okay?
All right.
We have John Frank Hires. Mr. Hires, good morning. Mr. Hires, you're here because you've been accused of violation of county probation in 25-37. That's a warrant, Mr. Hires, that's been out for you for a while. You've got a new charge from yesterday, and it's, Mr. Gill, the body of the complaint says knowingly driving while license suspended. The statute the officer used is knowingly driving while license suspended. On the front page of the complaint, the officer put unknowingly driving while license suspended, which is a non-criminal infraction. My understanding from the clerk's office is they have to go by the statute, correct? So there's probable cause for what he charged him with by the statute. But I'm asking the state to notify the officer that the front page and back page do not match. So you're accused of one count of knowingly driving while license suspended, new charge. You also have a violation of probation on probation for the same charge. Please listen to Mr. McDaniel, appointing him for public defense for first appearance purposes. We'll see where we go. Mr. McDaniel.
Your Honor, I spoke to Mr. Hires. He's going to plead of no contest to the new charge and admit the violation of probation. The understanding charges, the cases are run concurrent. He'll be sentenced to 4 months in the county jail, 1 day jail credit, $400 fine on the new one, and whatever fine is remaining in the violation of county probation case. He has signed his waiver, waivers right to jury trial and call witnesses.
370 is remaining in the old one. But he might have only paid $30. Okay. So Mr. Gill, is that agreeable with the state?
It is, Your Honor. And just for the record, Judge, I've been contacted by the Maryland Police Department. Oh, they will be submitting a amended affidavit.
Just because I'm curious, since he's pleading at first appearance, do they still have to do that?
I mean, I think they're going to. That's what they said. I mean,
Okay.
You're right. I think it's moot at this point.
Yeah, I don't know that. It's even worse if the statute's not right, but the officer had the statute right. It just got a typo on the front page. So Mr. Hires, any questions about that agreement, sir?
No, sir.
Is that the plea you would like to enter to resolve both these charges, sir?
Yes, sir.
Mr. Hires, I'm going to accept your admission that you violated your probation in 2537 CT, and I'm going to accept your plea of no contest to the new charge of driving while license suspended or revoked knowingly. I'm going to judge you guilty of both those offenses, sir. Sentence you to 4 months in jail on each case concurrently, running at the same time. So you have 1 4-month sentence. Mr. McDaniel, I did not write down the credit for time served. How much was that?
1 day.
1 day. 1 day credit for time served. Mr. Hires, $400 court costs and fines in the new case, $370 remaining in the old case. Mr. Hires, no probation involved in this sentence. You finished this sentence. You through with this case. Hopefully you'll get you some extra game time through the public works program. I do wish you the best. Do you have any questions?
Yes, sir.
Have a good day, sir.
Thank you.
Yes, sir. We had a bunch of cases for Friday today. Corporal, anything else in the jail?
No, Your Honor.
Mr. McDaniel?
No, Your Honor.
Anything else? Mr. Gill?
No, Your Honor.
All right, ladies and gentlemen, that concludes our first appearance.
It is hour 2 of TCF Live. It's good to have you all here on this Super Friday. Let's go to Texas. Let's check in with Judge Stevens.
Good morning. What are we going to do today?
Morning, Judge. Understand defense counsel filed a number of motions, Judge.
I'm sorry, say that again?
Motions. Sir, I understand defense counsel's filed a number of pretrial motions.
So when is this thing, when is this set?
September the 14th, Judge, for trial.
Set for trial, Judge.
Okay. All right. What are we going to do today?
Your Honor, I have, I believe 4 different motions that, we'd
Go
like
ahead.
to be heard today.
Go ahead.
First one is, defendant's motion to compel disclosure of the state's method of authentication, admission, and sponsorship of electronic evidence.
I think, Judge, I can, in short, the state will follow the rules of evidence and the code of criminal procedure in offering or authenticating any evidence that we offer at trial.
Your Honor, This case is going on, I think, 2.5 years now. This is a.
If we were the only one.
Or 7 trial setting.
If we're the only one.
In the 2.5 years, Your Honor, this is the entire notebook binder that I have. And none of my motions have ever been answered, by the state. I didn't even know who, with requests for, discovery or anything of that nature.
Have y'all met?
I have not met Mr. This new
Coleman.
Coleman,
Judge,
sorry.
I just inherited this case, as the court's well aware, in the third prosecutor case. I am happy to comply with all of our obligations under the 39
He's a good man.
of the Code of Criminal
I have
Procedure.
no doubt.
Brady and-
Get with,
Happy to do it all.
get together. I think he.
I have no doubt he's a great
He will,
man.
I think he can expedite whatever you need. But yeah, I just finished my 620th felony jury trial preside. Nobody's done that. So
Yes.
we're not hesitant to try cases in this room.
I understand.
And just whatever y'all need to prepare, get it done and we'll move forward.
I'll make it happen, Judge.
What do you need today, sir? Yeah, what can I do?
Well, as I also filed some motions in limine. I believe we can address those on the day of trial.
Thank you. Yeah, yeah.
And
As things evolve and sometimes a decision now gets changed as it gets right at trial.
there's also a motion to quash the indictment. I don't know if you want to hear that now or on the day.
Go ahead, summarize what you contend is a problem.
Yeah, Your Honor, we allege that the indictment fails to put forth any manner in which the complainant was harmed. I believe that we need adequate notice so that we can, adequately prepare for our defense. The indictment fails to mention how the complainant was harmed, if at all. And so in order for me to be able to prepare a defense, I need to know how she was harmed.
Your Honor, the state's indictment tracks the statute, and the indictment is intended, as I understand the case law, to just simply provide notice to the defense counsel of the nature of the allegations. And lastly, Judge, I'm not aware of any case law or any authority that requires us, at least at the pretrial stage, to demonstrate the nature of the harm to the complainant.
Well, how can I prepare a defense if I don't know what?
Okay. Are you saying that this indictment does not set forth the elements of the crime under section 42.072 of the Texas Penal Code?
Yes, Your Honor.
What does it fail to say that's in the statute?
Let me pull up the indictment if I can find it.
I've got it here. You want to look at it?
Your Honor, you cited 40, chapter 42. That's with regard to
section 42.
Section 42. Thank you, Judge. Just with regard to the stalking, we also have the companion case of publishing or threatening to publish intimate material. Just for the record, that's under chapter 21.
I'm just looking at stalking right now.
Yes.
Your Honor, just for the record, the one that's being tried on the 14th is not the stalking, it's the publishing.
Judge, the state gets to elect which one we try.
No.
And I haven't made.
Wait.
Your Honor.
You're right about that, but what are we going on? Which one are y'all going to go on?
Judge, I just literally looked at this case yesterday, and I'll figure that out. Judge.
Your Honor, these are already decisions that were made way prior to Mr. Coleman coming onto the case.
I'm not bound by the decision of a prior prosecutor as to which case to go forward on.
And Your Honor, just for the record, my entire preparation for trial has been on the publishing case, not on the stalking, because of the fact that we were told on previous court settings that the one that was going to be tried was the publishing case and not the stalking case.
Your Honor, they arise out of the same criminal occurrence.
Okay. All right. Anything else from anybody?
That's it.
Okay. Which one is the state intending to try first with this prosecutor? Yes.
Give me a second, Judge, please.
Yeah.
And Your Honor, one of the.
Judge, here's what I intend to do. I intend to file a motion to consolidate these cases and try them at the same time. He certainly can file a motion to object and make his argument to the court. These arise out of the same criminal episode, and as such, we're entitled to consolidate them.
Okay, in all fairness to him, have you told him that?
Judge, I just looked at, I got his motions yesterday. I just looked at the case yesterday.
Yeah, these motions have been filed for quite some time.
Judge, you understand the turnover in this court, and I'm drinking water from a fire hose to get caught up on the docket, Judge.
All right.
And Your Honor,
In all fairness, they, and it's not him, I mean, his boss makes changes, and there's a new prosecutor in town on this one.
Yes, sir.
So in all fairness, they get an opportunity to prepare, but you got to move forward. And the statements that the defendant was told on behalf of the district attorney's office that he relied on, in all fairness to him, he spends his time focusing on that. And when it's changed and a prosecutor gets to make an independent decision that's different from what had been told previously, then he has a fair opportunity to get ready for this. But everybody remember, this thing's 3 years old and moving past 3 years old. And we try cases here, but what is it going to take to get ready for this? And also, is that what you're telling the defense, that you're going to consolidate? You want to try both?
That's what I'm representing to the court and defense counsel. I will file a motion to consolidate as expeditiously as I can.
Okay,
that is my
intent. He gets a chance to be heard on.
And Judge, I'm sorry to interrupt the court, but one final thing. These are all out of the same transaction. He can't argue unfair surprise. Oh, I didn't know that this would become an issue.
Well,
because it's out of the same
he can argue
transaction.
whatever he, in good faith, feels like he needs to
I beg to
represent his client.
Your Honor, I can't argue.
I've never
unfair
heard
surprise.
that from a defense attorney. I beg to differ from the prosecutor. But here's, as amusing as this is turning into, let's move forward.
Yes, sir.
What is it we need, that you need from me, so we can get this thing to trial?
The state will be ready.
And yeah, again, we've done 620 trials here. Nobody's ever known to do such a thing. We try cases here. So it's not me that's the problem. What is it y'all need to do to get ready?
The state will be ready on September 14th to bring this case before jury.
Okay, but you want to consolidate. He's going to get a chance to be heard to how that plays out. And he also said that he was told by a previous prosecutor that it would be going one way. And so in all fairness to him, he has a fair opportunity to redirect his focus in light of the new prosecution, which he's entitled to.
I understand, Your Honor, but in my defense, I would just like the court to know that I haven't even begun preparing for trial for a stalking.
What do you need from me? What are you asking for today?
Well, I'm going to need some additional time.
All right, you got it. You got it.
Judge,
Yes.
this case number 14 aggravated. I don't.
Ma'am?
You special set these cases on September 14th.
I know it, but we've got an issue that's come up since then.
And Your Honor, I'm not sure when it actually happened. The lead investigator in these cases was
Yours or the state's?
In the states. The lead investigator was tragically killed in an accident, as you, I'm sure, are well aware of.
Okay, and so what?
It was her investigation. It was her evidence.
Okay.
It was her testimony that was going to be up for cross-examination.
Oh, okay. Well, I mean, okay. So
that's our issue, Judge, and we'll work within the rules of evidence.
We'll see what happens.
Code of procedure to make sure that we get whatever evidence we need to get in.
I was on the committee that wrote the rules of evidence. I think I can.
Yes, sir.
Okay. What do we want to do today?
Well, I wanted you to make some findings on the motions that were brought up to the court.
Okay, the motions being what?
On the motion to quash.
Denied. The court's read it, then the court is satisfied. It sets forth the elements of the statute in the allegation. But I want to make sure that you've got all the discovery you need for preparation.
Yes, sir.
What else?
And on the motion to compel,
Compel.
on the motion to compel the disclosure of the state's method of authentication, admission, and sponsorship.
I'll disclose that right now, Judge. We will follow the rules of evidence and the criminal procedure.
Well,
That's our method.
okay. He's I guess he's asking for how that's going to be done. And what do you say to that?
I say if it's photos, we will follow the rules of evidence that pertain to authenticating photos. If it's videos, we will follow the rules of evidence as it pertains to the authentication of video.
Okay. Depending upon what it is, give him a fair opportunity to know what it is so that he can prepare any objections if he needs to. Let's don't surprise during the middle of the trial, so we have to stop and everybody go and start over for prep.
Yes.
I don't want to do that. When we start, let's move forward from the beginning to the end without delay.
Yes.
And what else?
Well, the other motions were going to be taken up at front.
Okay. All right. All right. So what are you asking for the next event now?
Right now, I just need time to prepare because now he's going to throw in the stalking.
How much? Okay, I'm going to reset this for a review. How much is 4 weeks going to be good?
That puts us in October. Yes, sir.
Okay, 4 weeks.
Thanks, Judge.
Correct.
Yeah, it's going to have to be pushed off, and we'll have something else special said.
Your Honor, and I apologize for, but I just need to be able to adequately prepare.
Yes, sir. Okay. All right, just let's get it done so we can move forward.
Yes, sir.
We often use a relief after 3 years. Mm-hmm. Mm-hmm. Wow, the bond for.
Alrighty, friends, we're about halfway through TCF Live on this glorious Super Friday. Thank you all for spending some time with me this morning. Let's excuse me. Good heavens, that came out of nowhere. Let's go back to Magistrate Urich. He has an in custody person. Let's see what that's all about.
Mr. Smitherman, would you please state your name for the judge?
Corey Smitherman.
Thank you. Judge, we're both here via Zoom. We both consent to the use of Zoom for this hearing. I did explain to my client the sole charge of embezzlement, 1,000 or more, but less than 20,000. We talked about the possible penalty. We spoke of his statutory right to have a preliminary examination at the district court level. And should this matter be bound over to the circuit court or at any point that he demands such, we did talk about his constitutional trial rights. I believe he understood everything that we talked about, the nature of the charge, the possible penalty, the statutory rights and his constitutional rights. As such, Judge, I would ask the court to waive formal reading and I would stand my client mute.
Thank you very much for all that. Mr. Smitherman, you understand that as your arraignment, this is your very first, but certainly not your last hearing, correct?
Yes.
Good. So the court's going to enter a not guilty, repeat, not guilty plea on your behalf. And court-appointed counsel is noted and approved for the future. So the Oakland County Public Defender's Office will be assigning you a carefully selected MIDC sanctioned counsel to assist you in your defense every step of the way. Understood?
Yes.
In the meantime, you'll get a notice if you make your freedom today or any day soon to Bacon. That notice will direct you when and how to appear for a probable cause conference. As a felony, this matter entitles you to a preliminary exam. Pardon me. If probable cause is either found or waived within the next 21 days from today, the matter could be bound over to the Oakland County Circuit Court for further arraignment, trial, and proceedings. Mr. Angot, we now turn to bond. Mr. Smitherman, the court's got to set a bond this morning, and that's not intending to prejudge or punish you. The law presumes you innocent, but the court must set bond to ensure you reappear and pose no threat to the public. Mr. Angot, at least within the Berkeley narrative, it indicates 6 warrants out of Farmington Hills totaling in excess of $12,000. And obviously this matter, what would you like to share as to bond?
Judge, I appreciate that information. I was not aware of the Farmington Hills issues pending. That being said, Judge, I just note what the court already knows. This is not a crime of violence. Certainly the Farmington matter, I think now just prevents me from requesting a personal bond. So I would ask for a bond that the court and I believe will ensure Mr. Smitherman's future attendance to all proceedings. I would ask the court to consider a $5,000 10% provision bond, cash or surety.
Thank you very much. One moment, please. Thank you. Mr. Smitherman, the court is prepared to set bond and it will be with conditions. You will get all these in writing, so you don't need to memorize. Mr. Angot, presumably he had been employed by Burger King. What's his employment picture now? I'm sorry.
Corey, would you tell the judge where you're working now?
I work at Leo's County Island, Royal Oak. I'm a cook.
Judge, I suppose the other thing I would note, and I should have, is as the court is aware from his address, I don't believe he's been hiding from anything. I believe he did not know the warrant existed. I imagine if there was an arrest, it had to go to the Oakland County Prosecutor's Office, to the warrants division, and there may have been some delay between the arrest and the issuance of the warrant.
Thank you. Excuse me for just a moment.
Sure.
Mr. Angot.
Well, I'm not sure why exactly he cut his feet over there, and apparently neither is the wild rabbit that's running around just outside the studio, because as soon as that feed cut, the rabbit came running up like, I was listening to that. What's going on? All right, hour 2 of TCF Live. Let's stay in Michigan. Let's go to Judge Elmore, new contestant there.
All right, so our next matter on the record
Judges
is
like me can tolerate people like you.
yes. We have 2 files, each is entitled People of the State of Michigan versus Laura Marie Webster. 2 case numbers here are 26-14193FH and 26-14320FH. Ironically, the numbers could be in reverse, meaning the one ending in 320 deals with an allegation of possession of methamphetamine with an offense date of September 11th of 2025. And then the second file, which has the earlier number of 193, has an allegation of possession of methamphetamine with an alleged offense date on January 9th of 2026. We are here to address, and it's always odd in how this is stated, but it's really a motion in limine regarding the admissibility of evidence under Michigan Rule of Evidence 404B. The court has seen here that the government people have previously entered a notice of intent to offer evidence under that court rule. That was filed back on April 23rd. Then,
well, Your Honor, I don't mean to derail the proceedings,
but you're
except
going
that I
to.
will.
Yeah.
If I may approach, we have a presentation of some paperwork that will resolve both of the cases, thus rendering the motion moot.
All right, come on forward.
I'm sorry, Your Honor.
That's all right, Mr. Harrison.
Again,
I was on a roll, but that's okay. All right,
tried
one
to
moment.
warn
All right. So the parties have handed to me, or Mr. Harrison has handed to me a couple documents. The first one is a plea agreement. It's just missing a couple blocks checked, but I think I understand what it means. The defendant currently in file 320 is charged with possession of methamphetamine with a second or subsequent drug enhancement and or a habitual felony offender third and a hold on, are there two counts?
there are two cases.
Yes, no, hold on.
Okay.
I know what I meant. Sorry, in that file 320, there was an additional charge of retail fraud in the second degree. Lead to an added count 3 of use of methamphetamine as a second or sub. And she's going to plead guilty to a added count 4 for a retail fraud third. Is that right? And then the original count 1, the possession, with the second or subsequent or the third habitual enhancement will be dismissed. And the retail fraud second, which is a misdemeanor, will be dismissed. And the entirety of file 14193, which was a possession of meth with 2 enhancements, that'll be dismissed in its entirety. Is that correct?
Yes, Your Honor, but the controlled substance second one still applies to the use of
Yep, I got it. Yep.
Yes.
Is that correct, Mr. Harrison?
That is correct, Your Honor.
All right, Ms. Webster, is that how you wish to resolve today's file?
Yes, sir.
All right, 1 second. Please raise your right hand. Do you swear or affirm that the information and testimony that you're about to provide shall be the truth, the whole truth, and nothing but the truth? You may lower your hand. Make sure you speak up because Nancy in front of me's got to hear every word you say. And if she can't, she'll shake her head left and right, tells me no, then she gets mad. I don't know if you've ever seen the Tasmanian Devil. It's probably too old for you because that would have been Bugs Bunny. Anyways, turning your attention back to September 11th of last year, were you on bond, probation, or parole at that time? All right. Now, in that file, which is number 320, you are charged with 2 counts. Both of these counts will be dismissed, but I need to go over them with you. Count 1 is a charge of possession of the controlled substance methamphetamine, which is a felony punishable by up to 10 years and or up to $15,000. Now, there are 2 potential sentencing enhancements that could, in effect, within the discretion of the court at the time of sentencing, do the same thing. A second or subsequent drug offender enhancement or a third habitual felony offender enhancement would allow the court to increase that potential punishment from up to 10 years to up to 20 years, and from up to $15,000 up to $30,000. But that count 1 and its enhancements will be dismissed. Count 2 is a charge of retail fraud in the second degree. Now that is based upon a prior retail fraud would make it a 1-year misdemeanor. I should say that better. A misdemeanor punishable by up to 1 year and or up to $2,000 or 3 times the value of the property that was stolen. However, that count will be dismissed. Those will be dismissed if you enter a plea of guilty to, and I accept that plea, to an added count 3 of use of methamphetamine. Now, initially, a use of methamphetamine is a misdemeanor punishable by up to a year and or up to $1,000. However, second or subsequent drug enhancement can be used and will be that will allow the court to increase that potential punishment from up to 1 year to up to 2 years, and from up to $1,000 to up to $2,000 in fines plus costs. You understand? I'm also told that you're going to plead guilty to an added count 4 of retail fraud in the 3rd degree. Now, it's kind of odd. I'm going to do the best I can explain it. You're actually charged with retail fraud 3rd degree, but because you have a second or subsequent, meaning you've been convicted of it before, it becomes a retail fraud in the 2nd degree. It's a little confusing, but we're just going to list it as a added count 4 of retail fraud in the 3rd degree, which is a misdemeanor punishable by up to 93 days and or up to $500 or 3 times the value of the property taken. Do you understand?
Yes.
So far, is that what you agree to?
Yes.
Now, in the other file, which is going to be dismissed in its entirety, you are currently charged with a single count of possession of the controlled substance methamphetamine, which again is a felony punishable by up to 10 years and or up to $15,000. Plus, there are 2 potential sentencing enhancements added. 1, the second or subsequent drug enhancement, or 2, the 3rd habitual felony offender enhancement, which only 1 could be proceeded upon. Do the same thing. They would allow the court at the time of sentencing within its discretion to increase the potential punishment from up to 10 years to up to 20, and from up to $15,000 up to $30,000. However, if you enter those 2 pleas in the other file, and I accept them, the prosecutor will dismiss this file in its entirety. Is that what you understood?
Yes.
So now there's another element of this agreement, and it says that you agree to pay restitution, presumably for the retail fraud, to Meyer out of the north end, $187.88. Is that also correct?
Yes.
Now, this pretrial agreement that I've just gone over has 2 pages, and I'm going to hold them up for you. Here on page 2, is that your signature?
Yes.
Now, before you place your signature on page 2 of this agreement that will be placed into the file, did you go over page 1 with Mr. Harrison?
Yes.
Now, throughout the processing of this case to get to these 2 cases to get to this point, has Mr. Harrison been available for you to speak to, ask questions, to tell you about the facts, tell you about your rights, your options, going to trial, stuff like that?
Yes.
Are you satisfied at this time with his representation?
Yes.
Now, if you enter a plea of guilty that I've just discussed with you, you'll not have a trial of the kind. Does that make sense?
Yes.
Now, the second piece of paper that Mr. Harrison has handed to me is at the top. It says advice of rights. And at the bottom appears to have your signature again with today's date. Is that your signature?
Yes.
Now, before you place your signature on this page, did you read through all the rights that are above your signature?
Yes.
Did you understand all those rights?
Yes.
Do you have any questions about them? And again, do you understand that if you enter a plea of guilty today, and I accept those pleas, you'll be forever waiving these rights as they apply to this particular case?
Yes.
You will also be given up the right to claim that the plea was a result of any promise, threat, or inducement not told to me today on the record. So other than the terms of the pretrial agreement that we have just gone over, have there been any other promises, threats, or inducements to force or compel you to plead guilty that we have not discussed?
No.
Are you into the plea today of your own free choice?
Yes.
Now, Mr. Harrison has probably talked to you about potential sentencing, applied his understanding of the law and his perceptions and experience in front of me, trying to give you an idea as to what he thinks they may sentence you to. He's probably talked to you about the Michigan sentencing guidelines, which do not apply to misdemeanors, but because the use of methamphetamine as a second or subsequent becomes a felony. So the Michigan sentencing guidelines are issued by the legislature to help courts establish what should be a fair, reasonable, and proportionate sentence. I want to highlight for you that they are not mandatory. While a court must consider them, the court need not follow them. Have you talked to Mr. Harrison about potential sentencing?
Yes.
Has he or anyone made any promises to you or suggestions to you as to exactly what I would do at sentencing? So again, are you therefore entering this plea of your own free will still? Do you have any questions before I ask for your plea?
No.
Added count 3, use of the controlled substance methamphetamine. How do you plead? Asked to added count 4, retail fraud in the 3rd degree. How do you plead? Turning your attention to August 11th of 2025 up in Herring Township here in Wexford County. Did you have a run-in with law enforcement?
Yes.
Tell me about that. Where did it take place?
On what day? Sorry.
September 11 last year. Not the one from January this year, but the one from almost a year ago. This would have been, I think there was a traffic stop.
No, I think it.
I don't know.
The store called the police. They stopped me because of that. It wasn't traffic.
Oh, okay. Yeah. All right. I did not know that. All right. Thank you. So on that date, did he find you to be in possession of some controlled substance, methamphetamine, or that would happen?
Yes.
And did you know that it was methamphetamine? Yes. Or did you know that it was a controlled substance? Okay. This is where I always get a little sticky, right? So anybody out there in the world who thinks, oh my God, judges take pleas when people aren't really guilty, this judge will not do so.
Right.
Ever. So, and I also don't do what are called pleas of convenience. So the question here is, I need to either have evidence that you used it or evidence to support the greater offense of possession. Now, in either one, you either had to have used it or possessed it, and the it had to be methamphetamine, or you at least knew that it was an illegal or controlled substance, and that you did not have any lawful right to possess or use it. I don't know, but here's what I want to remind you. While most people think taking an oath is just something you do routinely and it doesn't mean anything, it does in a court. You raised your hand a couple minutes ago and swore to tell me the truth. So, if you did not know or you did not use, then you need to tell me. Now, by the way, what might be hovering over your head, while we have not yet gone over it, there was previously scheduled today to be a motion in limine regarding the use of one discovery in one file into the other file. I'm going to tell you that I'm extremely familiar with this court rule, Michigan Rule of Evidence 404B, and its progeny, and I can tell you that I would deny the use of that evidence to support the conviction. Just because you possessed allegedly once doesn't mean you possessed allegedly on the second time. It could only be used for other quote-unquote proper purposes. A proper purpose would be if you were testifying at one case and said, oh, I've never seen that methamphetamine before. Then the prosecutor could use it, maybe. But it cannot be used for what we call propensity. For instance, as long as you didn't testify and trick the tripwire that would cause an explosion to go boom, generally only would happen if you were testifying. I would not allow the prosecutor's office to use in its case in chief evidence of prior possessions or prior uses. It's a well-established rule. They could use it. And by the way, when I was a prosecutor, I would always file the motion for a notice of intent, so it would trigger the judge to do the next thing I'm about to say. You would never want to get on the stand, because I'm not telling you what to do, but if you did, you would hold the keys to whether or not that thing went boom. Because most likely only you could put it in to evidence. Maybe you got a character witness say, oh my gosh, I know Miss Webster. She would never possess meth. And then it could come. For example, All right, so what I've tried to do is let you know that the little thing looming over your head when you walked in, I've explained it. How I would rule if I were asked. So now I'm going to turn to you, and I've given you a couple minutes to wipe the tears. I need to know, on this date, did you knowingly possess methamphetamine? If yes, tell me. If no, tell me. Because once you say yes, I can't unring the bell. So if you need to speak with Mr. Harrison a little bit further, you may. You don't have to resolve this. Wait, are we here for a final pretrial conference?
No, this is not a final on this case. I think there is a final next week on that case, which is set for trial on the 22nd, I believe.
You can always resolve it next week if you need to, but I've got to move on to other files.
Exactly.
And I don't necessarily want, while I've kind of tipped my hat, and we still have to allow the people to make their arguments. But I'm going to say that it's an extremely well-studied rule. What? And hold on. We're going to take a brief break because I can hear what you're saying. And what you want to do to get a benefit is not the decision. The want to do has to be based upon you telling me the truth as you understand it. I cannot let you take a deal because you want it. You can only take a deal because you want it and it's true. From your perspective. Remember, right now I do not know what is true because I haven't heard any evidence. So we're going to take a little break. I'm going to come back to this, but hold on, before we do that, because we may not need to come back on the record, let's go ahead and deal with our motion. Ms. Dahl, maybe because the motion was relative, notice is relatively short, and so maybe there's something that I missed. Go ahead. Ms. Dahl?
I believe it's Mr. Harrison's motion, but
It is,
I can
but
respond to it if.
It's the people's burden since it's the people wishing to seek the admissibility of the evidence.
Your Honor, based on the court's earlier statements about the intention to rule against it, I would propose that we limit the testimony because I do believe it's relevant to where she hides contraband in her vehicle and why the officers did what they did and searched her vehicle in the trunk compartment, because in the prior case, the one that's currently in front of the court, they were doing a probable cause search for the stolen items from Meyer and from Walmart. When they went through the trunk, they found the methamphetamine in like a wallet type bag where her ID was.
Were there any admissions in either file and the other file that, hey, yes, that's what I do?
No.
All right, so here's the answer. Go ahead. Anything further?
Yes, Your Honor. So if we were to limit that evidence was found in the trunk, contraband was found and not the word methamphetamine or drugs, I think that would still provide the prosecution the evidence that she knew something was hidden in the trunk, and it shows the intent of her to hide things, meaning that she knowingly and intentionally possessed methamphetamine without being prejudicial to the defendant in stating that it is methamphetamine, because the defendant's motion is that we're trying to prove that she's a meth addict, but that's not what we're trying to prove. We're trying to prove that she knowingly and intentionally possessed it in the trunk and hid it in the trunk, which shows that it was her intent and knowledge that this was contraband. So if we limit the language to contraband and evidence presented in court as contraband found in a trunk in a prior instance, I believe it would protect the defendant's right from undue prejudice and also allow the prosecution to present evidence to show that she knowingly and intentionally hid items in the trunk of her vehicle, which I believe is an element that we have to prove. So I believe that finds a balance to where it's not highly prejudicial or unduly prejudicial to the defendant, but still allows evidence that goes to her mode of hiding items in her trunk. Thank you.
Mr. Harrison, you don't need to talk. I appreciate the argument, and I'm gonna say this, and I want to say it, and I don't mean anything negative about it. I really encourage the prosecutor's office here to delve into the research a lot more thoroughly. This is such a well-explained rule of law. There's nothing that was that you argue here that is going to allow it to be admitted. There are literally hundreds of appellate decisions almost identical. So, can you use it to show motive, operandi, and scheme? Maybe. But you'd have to prove the first one. Let me give you an example. Let's say Miss Webster is robbing banks, and she's been convicted of robbing banks before. And the last couple of times she was convicted because she was wearing a particular mask of Ronald Reagan. And she always went in and held up the same kind of gun and did it the same way and said, "Give me the money, you filthy Democrat." I don't know, just trying to make it a little bit more comical. But you would have to be able to prove that was her. And you'd know it because she'd been convicted of it. Here, we don't know. That's why I asked if she made an admission. So like in one instance, if she had made an admission, "Oh yeah, that's where I store my meth," or "Oh yes, I put that there." But what we don't know is, did she do it? And so because the one question hasn't been answered, you can't get there from there. Now, also, it can only be used to show a proper purpose such as a modus operandi, which I know is kind of what you're arguing, or a scheme. You have to still have that fact proven first. You can't prove both facts in the case. But really what you can do is you can only use it to show her intent. Her intent would be if she testified and said, "It was a mistake. I didn't knowingly possess it." And I can't limit the defendant's testimony at all. It's her right to testify if she chooses. I can't limit anyone else's testimony other than when I can find that it is irrelevant. So I do find that it's irrelevant. You can't offer it underneath 404B because in effect, no matter how you soften the edge, it's designed to show propensity. Now, the conflict that I think that people are having here is understanding maybe a general definition of propensity and then trying to say, well, how does that make sense when the rule says we can use it to show a common scheme or intent or knowledge? If you delve into the research, it will tell you that it can only be used when there is some kind of evidence or testimony that she didn't know it was methamphetamine. She didn't knowingly put it into her trunk. I really appreciate it. And I try to send the attorneys links to case opinions that I get, because I read all the appellate decisions issued by the Court of Appeals, the Supreme Court, on especially criminal cases, since I deal with 66% of my caseload is criminal. This is such an easy issue if we continue to do the research. I encourage you to spend at least a day or 2 days reading opinions on it because it's so clearly defined. Again, the best thing about 404B when you're the prosecutor's office is you submit the notice of intent like you did, then it trips the defense attorney to say, no, judge, we don't want that. Then I get to go, "Mr. Harrison, you are correct. Prosecutor's motion is denied." And then what you do is you get the benefit of it to the defendant. She has now heard me say on the record that she theoretically, depending upon which witnesses she wants, let's say she wants to bring, right now a lot of appellate attorneys are attacking defense attorneys for being ineffective by not producing a witness, and say, "Oh no, she would never do drugs or never possess this." Trips it. Arguably could. Then it can come in. Or, so let's let Mr. Harrison know, he probably doesn't want to call a character witness and say she would never do this. That would open it up. Then, if you got on the stand and said, "Oh no, I've never possessed methamphetamine before, I don't even know what it looks like," then maybe you trip the door for intent or knowledge. So this is a very good exercise for prosecutors to do and for defense attorneys to file this motion because it helps eliminate appellate issues later on. But and plus I have to also use another rule, 404, 403. Is it more prejudicial than probative? I substantially outweighs it because without it, the prosecutor was left with that question of how do they prove intent? The answer here is it is denied. The prosecutor may not pay attention to this. I know Mr. Harrison's getting it. In its case in chief, present such testimony. These two cases have to go to trial. If they do, separately, there cannot be joint because they would only be trying to use the evidence of one to support the evidence of the other. Therefore, there would never be any joint trial either. Again, I appreciate it, and I'm not trying to be rude. I'm just saying this is such a well-ruled, studied, argued issue. And I'm 100% confident I nailed it today. All right, we're going to take a recess. So now I've ruled on the motion. Madam Clerk will draft an order on our journal sheet here today. And Mr. Harrison, you can come back and let me know what we're going to do with Ms. Webster's file. Right now, I can't accept the plea without the admissions.
I did enclose a proposed order with my original submission. Maybe the court can simply review that and see if it's deficient.
All right, hold on. I think that motion was actually filed in the other file, 193. Yes, because that's the later event.
It's a little bit unclear, but I did refer to that particular search as the September 11th stop.
Hold on.
It's a little cumbersome, I agree.
All right, I'll go ahead and sign the order that's contained here in the file.
Thank you.
Yep.
Alrighty, friends, entering hour 3 now of TCF Live as we just witnessed Judge Elmore doing his best Judge Mogan impression with, as Lindsay put it, a stream of consciousness. Okie dokie. Earlier, P. Diddy sent us a high five. Jonathan sent us a treat. Thank you both for that. And Joy Bag of Donuts gifted us 5 memberships. Thank you, J-Bod. Appreciate that. Reminder once again, everybody, too. I think it's still pinned. Yes, it is. The pinned chat. We have a casting call for joining us as sidebar panelists. Please do check that out if you have any interest at all in lively discussion. We'd like to add a few people to our bench. So do check that out. Click on the link there. The casting call will be open until the 15th of September, so you have a little bit of time, but I'd encourage you, if you have any interest at all in joining us, to submit your information. Let's take a look. Let's see if you're a fit. Should be fun. Okie dokie. Let's go back to Judge Stevens. Looks like he has a fresh contestant.
Yes, good morning. This is a 3-month review to check his status, and my understanding is, from talking to probation, he's doing well as far as the review today. I think it was a 3-month review. And he is gainfully employed, right? All right. Sorry about that. I was in. And I did talk to the probation officer, and she's fine with continuing in on supervision.
Shuffle the deck, somebody. Shuffle the deck.
Let's all up and come to this. Okay, I don't need it.
And clause number 21-37762 is called State of Texas versus Devin Alexander Sampson, the defendant. There's a pending motion to revoke unadjudicated probation, right, on this?
It is, Judge. I believe the court held it in abeyance at some point, according to my notes.
I didn't make any, the motion was, listen, motion to revoke held in abeyance. It says 3 months.
Right.
On 6/1/26, but the court did not make any findings on this. We just must have held it.
Cause y'all wanted to see how well he was gonna do. And what,
But see, I didn't, we must not have had a hearing because I didn't write on this of him making pleas.
I don't think so.
And it's, so we didn't have a hearing on him entering pleas in the matter. So there must have been something else that caused the court to postpone it. Was it preparation or something for you?
I think.
What happened was he committed a new offense and he was.
When?
25.
October 2025.
Okay, that's different from these 4 allegations here in this motion.
So this was one of the allegations.
No, it's not, because, okay, allegation 1 states he committed the offense of criminal mischief on or about October 2nd, 2025. Number 2 says failed to avoid injurious or vicious habits. 3, failed to immediately report community supervisor the arrest. And 4, failing to pay fees. So the only crime charged is a October 2nd, 2025 Class A misdemeanor for criminal mischief.
Yes, sir. That's it.
I didn't make any findings on it because I didn't write anything on it. So let's see. MTRP status hearing. On August. This is August 24th. Was that 4 days ago? We were here? Couldn't it be?
No, no, sir. No, it's been a while since we've been on him.
Yes, that's correct.
And like I said,
Looking at
understanding, you just wanted to see how well he was doing.
Hold on.
And she was gonna tell if he was doing right. And I think she's saying is he doing good?
I had an order, I signed an order amending the conditions of probation.
Check the stats.
Quick pause here just a minute because Julie asked a valid question. What the heck is failed to avoid injury? So in Texas, failure to avoid injury usually refers to a driver's legal duty to take evasive action or keep a proper lookout to prevent a crash, or it relates to criminal charges from failing to stop and render aid after an injury collision. That is what our Google lawyer says, so that gives a little bit of context, hopefully, maybe. Anyways, back to Judge.
Signed August 24th, 26th. That's weird. Which would have been 4 days ago.
Yes, sir. But no, this wasn't no kind of a hearing or anything like that.
Okay, when does it show amended? I signed
That would have
it.
been to prioritize his restitution because he does owe restitution.
When would I have signed? Is this the correct date of the order amending conditions of probation? So
Yes,
that was 4 days ago.
yes.
Oh, okay. All right.
So we all good.
Oh, so that's
right.
Here today, MTRP status hearing on the docket. What is our status for this motion to revoke unadjudicated probation that is pending? It was filed in April, so.
He's doing well. He's reporting as directed.
Okay. What's the state asking? Are we just not moving forward on this, waiting to see how he does?
Judge, I understand this is to agree with Mr. Adams. I can't believe I'm saying this. I thought this was a status hearing, and I visited with the probation department, and she's saying that the status.
Okay. Yeah, I thought the motion was filed in April. What do y'all want to do with it?
Oh, Judge, with the court's permission,
yeah,
I'd like to withdraw the motion, Judge. I'll dismiss the motion. Under these circumstances, given the representation of the probation department that
send me a dismissal and we'll
comply. Yes,
so we're just from probation. We just continue him. He's on probation until 27.
Yes, sir.
And what do we want to do from probation today?
We want to continue him on probation.
Okay.
Thank you, Judge. Appreciate
that other thing will be dismissed.
Y'all pick it. You good? Just keep doing right. Stay out of trouble. I got it. Okay, I do that right now. Thank you, Judge.
Okay, on Christopher Smith, is this true? The federal government
Yes, Judge.
got him?
Yes, Judge.
So he's not
He's
in town.
No.
And what do we do on this case today?
I believe, Ellie usually puts them on their own federal based docket to check and make sure that they're still in Fed custody. And then
What's
once
the
they're
word on
back
it?
to us,
You know,
he just had his arraignment this past week, Judge. So
in
he,
Feds?
yes,
Okay, what's he charged with there?
same thing.
Child pornography?
Yes, Judge. His timeline with the Feds just started this week, so I expect.
Hey, well, where's the state on this? Yeah, are y'all just holding this to see what the feds are going to do? And is this an overlapping set of facts, or is this a different set of facts from what the feds had on them?
It is overlapping, Judge.
Okay.
And we are speaking and in communication with them to see how we're
You know
going to
where
proceed.
when there might be a disposition in the feds? We don't know.
No,
yet.
I think arraignment was just.
Because on something like that, they're not going, I don't think probation's in the
No, I
in the
agree.
mix for them.
Not at all.
Engagement with the Feds is anywhere from 15 to 40, I believe.
And probation
Just
is not on the
statutorily.
table for us either.
15 to 40 years?
I believe, yes, Judge. At least with the guideline calculations.
The parole stinks in the feds, you know that. You don't get, you do that time. So what do we do with this? Just kind of hold it and review it in a few months to see where the federal government is on
Yes,
it?
sir. Yes,
That shall be done.
Thank you.
That's all. Christopher Smith, cause number 26 CR 662. Why don't we review this in 3 months? Okay. Randy James. It's Johnson. I just wanted to see if you knew I was going to change his name. All right, there is a first amended motion to revoke unadjudicated probation in 23 CR 1233, the state of Texas versus Randy James Johnson. That's you? Yes. Let's see. Theft. DWI. Failing to report. And there's a first amended resisting arrest. You're kidding me here. It's a different date. Public intoxication. On my watch, you're alleged to have committed two different sets of crimes on two separate dates, notwithstanding the other 9 allegations of violations. Okay, this was filed in February. Are we ready for a hearing?
No, Judge.
Judge, we have fashioned a deal that will ultimately resolve this motion.
Maybe.
Probation.
Let me hear it since I get to decide.
For the resisting arrest from December of 2025, there is going to be a 30-day jail sanction added to that. And then once he has done his jail sanction, then he will be reinstated, or the motion to revoke probation will be dismissed moving forward.
That's correct, Judge. And I've just visited with the probation department about that. And I think she has maybe some additional things she'd want to amend his probation conditions to include as a result.
I'm anxious because there are 11 violations. Are you kidding me? We made a big deal. I mean, 11 violations are alleged and crimes, 2 crimes.
I think Ms. Minaldi.
Hold on, let me speak.
Yes, sir.
Please.
Yes.
Thank you. So y'all can just deal with what I'm concerned about. This never happened. You don't get 11 violations and then sashay out of here. What's going on?
I think Ms. Minaldi can speak to the fact that it was originally those initial allegations were dealt with in a previous proceeding.
That's correct, Judge.
And then there were 2 other, the misdemeanor resisting.
So 1 through 6 are from a first motion to revoke probation that was filed,
7 through 11.
and then 7 through 11 is a subsequent.
Which includes another crime.
I understand, Judge.
But those initial ones, they were dealt with, they were adjudicated.
So we're only here on 7 through.
They were adjudicated, Judge, right?
Who?
I mean, didn't we?
We resolved those.
We did 1 through 6. That's all we did.
1 through 6, we resolved with,
We only had 1 through 6 dealt with it, and then thereafter, this first amended motion rolls over, and we haven't had a hearing on that, which was 7, 8, 9, 10, 11, including a resisting arrest on December 12th, 2025.
And just to be clear, I think, I just want to make sure.
Hold on, let me look at something.
Yes, sir.
Yeah. Because this isn't clear to me, and y'all have to make it clear because this doesn't make sense. We had a hearing.
That's right.
On June of last year.
Yes, sir.
And June 4th, and he admitted to committing a crime, driving while intoxicated. And this was, there were other miscellaneous violations that were not substantive crimes, but were other conditions of probation that were allegedly violated. But he pleaded true to the driving while intoxicated while on probation. And we resolved that on June 4th, 2025.
That's right.
This first amendment comes up. It alleges that 5 or 6 months after that hearing, it's alleged that he committed the offense of resisting arrest. Okay, how many chances do we get here?
And we're thinking that we're thinking the appropriate sanction would be 30 days, sitting 30 days in jail on essentially a misdemeanor resisting, which is what he would get in all likelihood if it was a standalone misdemeanor offense, and then continuing on probation. At least that's our calculation, our thinking, Judge.
and then that would dismiss the motion to revoke probation after the resisting arrest was handled.
Judge, probation just made a great point, and I'd like to share that with the court, please.
Yes, Judge. In reviewing his file and his financial obligations, he is making payments to restitution. He has a balance of $680 left. So
to revoke
to the victim.
Meanwhile, he's committing crimes.
Yeah, I understand, Judge.
You don't buy your way out of trouble,
And it is.
do you? Oh, Lord. Let's just think of what we're doing here. We sent a message. Now, what's good? Everybody else who's on the motion to revoke docket is going to walk up and say, I want the Randy Johnson job. Well, I can commit a couple more crimes here and I can sashay out of here.
30 days.
What's fair is fair.
30 days in jail, Judge. We're not just cutting him loose completely. But I get where the court's coming from.
And we are moving cases as well, Judge. And I get where sports coming from on that end too, but
Yep. The first condition of probation in every probation order, do not commit a crime. He's committed 2 now since we put him on probation. And so we let him walk out of here.
With 30 days as a sanction.
He's on probation for a state jail felony. That's what the violation here. They've got the misdemeanor in another court. That's not what I'm worried about. I'm worried about violations of probation. That you made promises. Okay, let me go. Okay, begins with at 10:36 p.m. There's got to be a curfew violation here, right? He's supposed to be at home. Yeah, from 10 p.m. to 6 a.m. So he's out on the road at 10:36. Busted that one.
are we talking about violation number?
The
2?
December 12th, 25. I'm looking at the probable cause.
Oh,
Police go to Killarney Drive. The vehicle, while en route, police are advised the vehicle is running, parked on the wrong side of the road, and the driver is passed out at the wheel. On arrival, let's see, EMS advised keys to the vehicle were on the hood of the vehicle. I observed the vehicle was not running. I observed officer speaking to Randy Johnson sitting in the drive-in. Multiple verbal commands were made for Johnson to get out of the vehicle, in which he failed to comply. I detained Johnson in handcuffs and appeared to have slurred speech and bloodshot eyes, unsteady on his feet, failing to comply with simple commands. It is my belief Johnson was intoxicated on something. Due to the fact he was obviously intoxicated in a public place with no responsible person to take care of him in the middle of a public roadway, it was my belief he was in danger to himself and others. I placed him under arrest for public intoxication, secured him in the patrol unit. Johnson was then transferred to my patrol unit. I transported Johnson to the jail. On arrival, he was asked multiple times to step out, in which he refused out of the vehicle. I attempted multiple times to assist him out of the vehicle, and he was resisting me. He was not, and he stated he wasn't getting out of the patrol unit until somebody else came. After a brief struggle, I was able to use my physical strength and agility by grabbing him by his upper body and assisting him out of the patrol unit. He was then assisted inside the jail and booked. Okay. Go ahead.
Well, that's kind of where we are, Judge. We understand the court's concerns and hesitancy in adopting or accepting our agreement. That is our agreement in the court. You understand your authority. You're free to reject our agreement.
Yes, I am, and that's not going to do it. Now, there are ways of handling this, but this isn't the way I want to see my probations done. You can't be placed on probation, make a promise, and then commit 2 more crimes while on probation, and then say, let's just pick up where we left off. I'll go to jail for a few days. No, that's not the way it works. Y'all got to figure something else, or else I'll do it.
Understood, Judge.
What I'm going to do is reset this for 2 weeks. Y'all review it, y'all decide. But somebody on deferred or unadjudicated probation gets arrested on 2 separate crimes. If those are valid arrests, then they're not going to stay on deferred. Catch my drift.
Yes, Judge.
Okay, it's 2 weeks.
Thank you.
It's hour 3 of TCF Live on this Super Friday, the last Friday of August. I can't believe we're about to enter September. Crazy, crazy how quickly this year has gone. Let's do this. Let's go to Wisconsin and the governor's parole, or pardon rather, advisory board. Let's do a couple of hearings with them. Now, just to refresh, in case you haven't seen these people before, we will not get rulings on this. They advise the governor who makes the final decision, but these are good for the stories that they tell. So let's watch a couple of them.
Mr. Johnson, I believe I see you in the Zoom. If you can hear me, we're ready to hear from you. Okay. Mr. Johnson, if you're having tech troubles, we'll have someone reach out and help you try to troubleshoot that. In the meantime, we'll go on to Logan Eldred. Mr. Eldred?
Good morning. First and foremost, thanks for accepting my application and giving me this opportunity to plead my case.
Mr. Alfred, I'm sorry to interrupt you, but you're a little bit quiet. Could you possibly move closer to the microphone?
Good morning. Thank you for this opportunity to plead my case with you guys. I'm 46 years old. I spent most of my life in Wisconsin. I grew up in Milwaukee on the south side. When I was about 19 years old, the the police were called to my house for a heroin overdose. I had like 6 marijuana plants growing in my closet. So when the police showed up, they found the plants. I had to go to court for that. I ended up getting 3 years probation with a 1-year state sentence. At that time, I had not learned anything. So it wasn't long before I actually ended up getting revocated. There was a drunk driving incident. I ran from the police, and then also I had marijuana in my pocket, which was my second offense, which turned into a felony. I ended up doing 18 months in prison. My stay there was successful. I did acquire my GED while I was in there. I completed a AODA 5C drug program, as well as learned a few good, healthy habits, such as exercising, reading, and things like that. When I got out, I mostly focused on raising my kids. I worked odd jobs and whatnot. I did end up successfully completing my parole. I did spend a few years collecting materials. I was going on Craigslist and asking people for hygiene products, clothes, mittens, and stuff like that. And what I was doing was making homeless people backpacks just for them to be able to have their basic materials and supplies to get around. So I drive around Milwaukee and like go where homeless people go and hand them out. I did have some issues after that. I did have a possession charge of marijuana. I also had OWI as well, which was also THC. Since my last conviction, though, over the last 9 years, I've haven't had any issues. I've been sober. I've started a new business. I'm a farm-to-table hemp producer. We have 2 locations. One location we actually offer therapeutic massage as well. I have full custody of my 14-year-old and 12-year-old. We homeschool. We're raising our own chickens, and we have a huge garden, a lot different life than what I had known living in Milwaukee versus the little town I live in now. I am asking for a pardon today. I've had a lot of issues as far as job opportunities, having rental opportunities, things like that because of the drug manufacturing charge. And even recently with my business, they've started making, you have to have a license for the CBD vapes. So being a felon, I can't get a tobacco vape license. So that's really cut into my business as well. I do want to pursue other things such as possibly being a realtor. Now that I've actually gotten some experience in the business world and some capital, there's other things that I'd like to pursue that I know that a felony will prohibit or stall out. So I mean, with that, if there's any questions I can answer, I'd love to.
Thank you, Mr. Eldridge. Questions from the board? Cindy.
Yes, good morning, Mr. Eldred. So you had issues and criminal offenses involving heroin, THC, and alcohol. What is your usage of any of those substances now, and how do you maintain sobriety from them?
Well, what I found, and I think this speaks true for a lot of people, the best way to stay sober is stay busy. I do have a lot of things I'm invested in as far as my time goes. A lot of different music. I've been playing music for a long time, but also started picking up the bass, drums. I do homeschool too, so we're very busy with that as well. And I do own and operate a business. Yes, staying healthy is also a very important thing to sobriety as well. having a good workout plan, eating correctly, making sure you sleep, all those things combined, and having good goals, I think, has really helped me stay on the road. As far as drinking goes, I do not drink at all anymore. I haven't drank in a real long time, over 10 years. As far as any other drug use, I do own and operate a hemp THC store, so occasionally, if I can't sleep, I will have a Delta 9 gummy to help me sleep. But nowadays, honestly, I just kind of get a little anxious when I smoke, so I just kind of don't do that anymore.
Thank you.
Other questions from the board? Mr. Eldred, a couple from me. I see the OWI here that you mentioned. Was one of your children in the car with you when that occurred?
I had both my children in the car at that time.
Okay. And what happened? Was there an accident, or were you just pulled over for erratic driving? Can you tell us a little bit about what happened there?
So apparently somebody said I was driving erratically, and they started following me. I noticed that they started following me, but I didn't know why. So I had actually drove to the police station myself, because I thought that was the best idea. But then it turned out he had called the cops and said I was driving erratically, and then I was there, and then this whole thing unfolded.
Okay, and I believe you mentioned that wasn't alcohol, that was THC, is that correct?
Yeah.
Okay. And then I want to ask you, I see there are 2 restraining orders, one from 2016, one from 2020. I want to ask you about that most recent one from 2020. What happened there?
Was that with Miss Burlingame?
I don't know. The court records protect that information, but it looks like in 2020, there was a domestic abuse restraining order with a 4-year injunction with firearm restriction granted against you.
Okay. Yeah, I'm pretty sure that was with Jeanette Burlingame. I was in a custody dispute with her, and I was kind of getting I was pretty much losing my son completely, is what was going on. And I said a few things to her that I probably shouldn't have said. And then she filed, that restraining order. I ended up not even going. I just blew it off. I probably should have went and said what I said. What I told her was I was when my daughter turned 18, which is my youngest child, I was gonna smack her silly, which I obviously I shouldn't have said. But that's what I said. That's what she was bringing me to court for.
Okay, and was there a physical altercation as well?
No, there's nothing like that. No.
Okay, and then just the last question is, why was there a firearm restriction granted? As you probably know, you can't have firearms as a felon, so were there guns in the home or that you had access to?
No, there's no firearms in my home. So I don't really know why. I never even thought that was weird or anything. I just assumed that's automatically what they say.
Okay. Any other questions from the board?
I have one.
Myrna?
So if you're free from all those drugs that you talk about, and how do you justify selling vapes when our children under 18, it's getting out of hand? And there's a lot of things added into those things. Strong drugs.
Well, as far as the vapes we sell, I mean, there are some THC cannabinoid vapes that are allowed legally.
My question is, how do you justify that when you are clean, supposedly?
Well, I mean, honestly, I don't feel there's a justification needed. I mean, it is a legal product. People drink. It's legal. I mean, I am sober and I am against hard drug use. Pills, heroin, cocaine, these are all things I've had vast experience with, and it really hurt and affected my life. But honestly, this day and age, I don't think marijuana is exactly a bad thing. I think it can be misused, but it can also provide a lot of comfort and relief for people, which I do know because I do that firsthand. And you'd be surprised actually how many of my customers are actually in their 60s, 70s, and 80s that come in. We do a lot of good for the community in that respect. So it's really hard for me to feel like I'm doing something wrong in that regard. Because
Okay, thank you.
All right, thank you, Mr. Eldred. I believe that's everything from us. We appreciate your time today and hope you enjoy the rest of your Friday.
Thank you, guys. Have a great day. Appreciate it.
And Mr. Johnson, I believe we have your tech issue sorted out now. If so, we're ready to hear from you.
Can you guys hear and see me now?
We can. Go right ahead.
Good morning to all of you all this morning, the members of the board. My name is Stephen Johnson. I'm here seeking a pardon and forgiveness for the crimes that I committed 30 some odd years ago, I believe. I'm not really for sure the dates. I was a young man at the time, doing things that I shouldn't have been doing. I was riding in a car with someone, and I was party to a crime of delivery of a controlled substance of cocaine. I was placed on probation for that. I was doing my probation time, and I ended up being arrested for being a felon carrying a concealed weapon. They ran that time consecutive with the probation time. I did that time. Some of the time I was in the house correction for part of that time. The other part of the time I was sent to Oshkosh, where I took up a class and started getting my GED. I stayed out of trouble the whole time that I was in there incarcerated. I did almost finish getting my GED. I wasn't able to finish because at that time I was moved to a halfway house and I couldn't complete that. So once I was released and taken off of the ankle monitor that I was on for like 90 days, I did go down to MATC and did go ahead and complete that. I had to start it all over again because they had a problem with getting my records from there to whatever, however that was going. So I just went on ahead and took the tests over. I completed that. Excuse me. I'm not making any excuses for what I did. It was stupid of me to do that. I had no reason to even have a firearm with me. I didn't have it to hurt anyone or anything like that. I had it more for protection. Since that time of my release, I've been working. At that time, my girlfriend, who is now my wife now, we've been together since that time. We raised 5 children together. We lost a son back in 2019 there in Wisconsin due to a robbery that went wrong. I have our other 4 children. We've raised, my oldest son has his own business where he's doing deliver medical supplies. My oldest daughter graduated college with a degree in teaching. My youngest daughter now is going for her master's in law. My youngest son now is stationed in Hawaii, who is a Marine. My wife and I went there last year, visited with him, celebrated our 25th year anniversary, renewed our vows. Majority of the time that after being incarcerated, I spent a lot of my time just raising my children, helping my wife out with the kids and everything. We bought our first house in '94 that we just sold last year. I did do volunteer work as my children were growing at that time with their school. I would volunteer on field trips, what they will call, I would help the students whose parents weren't able to be there. I would chaperone. I would take a group of kids with me as well as my own kids. I volunteered with sports that they had. I would go to community events and do a little talking to some of the youth at programs, letting them know what my mistake was, and hopefully it will help them to detour from what they were going through. to help them out. I'm a certified forklift driver. I've been doing that for over 20 years. I moved here to Texas in 2016. My job when I first got here, I was working at Daikin as a forklift driver / trainer. I would train the new employees coming in on how to operate the machinery, the forklift. I did that for 4.5 years. I left there. As you can see now, I'm a delivery driver for Amazon. I've been doing that for the past 5 years now. I just kept myself out of the way. I seen that one time that experience that I went through of being incarcerated and not being able to be around my family and loved ones. I just didn't want that to happen to me again. And I avoided all of that, and I just stayed out of trouble.
Thank you, Mr. Johnson. I want to open up to questions from the board. Board members? Cindy?
Yeah. Good morning, Mr. Johnson. As part of the application process, applicants are encouraged to submit letters of support for their application, and you chose not to submit any. Can you tell us why not?
Actually, they did. I did submit some paperwork through the lady who was helping me go through all of this, get everything set up. So I don't know why she didn't send it to you guys, but I did have at least 3 or 4 letters of support that you guys should have had received.
We didn't get those, Mr. Johnson. We will follow up with that preparer. If you have copies of them, you're also able to email those to us directly. That would be great.
Okay. Is there any way I can email address or anything?
Yeah, the email that reached out to you about today's hearing, you can just reply to that.
Okay. Okay, that would be great. I'm seeking this part and asking, like I said, for forgiveness for what I did. The reason why I'm asking for this is my wife and I were trying to open up a daycare center here in Houston, and we went through the process and everything. And with this felony on my record, it stopped all of that from happening. I'm just hoping that I'm able to get this pardon where we can keep moving forward with our lives.
Thank you, Mr. Johnson. Other questions from the board? One for me, Mr. Johnson. It looks like in 2008, there was a domestic abuse restraining order granted against someone with your name. I understand you have a quite common name, but can you tell me if that's you or if you've ever had a restraining order granted against you?
No, I've never had anything like that.
And were you already living in Texas in 2008?
No, I was still in Milwaukee.
You were in Milwaukee. Okay, thank you. Any other questions from the board? All right, thank you, Mr. Johnson. We appreciate your time today and hope you enjoy your weekend.
Thank you all, and you as well.
Thank you. Next up, we have Cameron Miller.
No, actually, we don't. But we might catch Cameron Miller on an episode of Second Session at some point in the near future. My friends, we aren't going to listen to Cameron Miller because it is that time. That time on a Friday where we go to the courtroom where everything is super loud. A printer that never stops running, the screams of the undead in the background, children crying, defendants wailing in pain. It'll be a little different this morning. Judge Capper was called back to the underworld to oversee a trial where one of the dead has unfortunately been accused of not being sinful enough during his life. We'll have to see how that goes. But in this particular courtroom today, the person sitting in will oversee souls that are destined to be damned. In a courtroom that's lighted with equipment from Soviet-era war rooms. It's a scary place. They say Appalachian justice is best served in a cold, dank basement. Therefore, my friends, I give you Dungeon Court.
It's the state of Ohio versus Rebecca Boyles, PRC 26265, A, B, and C. Boyles, I haven't seen much happening on this since March the 10th. Have you made any other payments?
No, I was going to make a payment today whenever I leave. And then I was going to do my last 2 days of community service this weekend and next. because Saturday's the only day I have available to do it. And then I've got the class scheduled for September 18th, which is why I couldn't come on September 18th, and I'm here today.
All right. We'll set you back for a new review on October 16th. And that'll be a review at 9 a.m.
Okay.
Thank you.
Thank you.
Joseph Atkins. This is State of Ohio versus Joseph Atkins, CRB 23356. And Mr. Atkins, it looks like you're down to $50. Well, that's been actually, yeah, you're down to $50, Ron. Yep. That's all you got. You can either continue making payments about once a month and drag this out, or you can either pay it or do a day of community service and wrap it all up.
Yeah, we'll pay it off next week.
I'm gonna set you back for October 16th for review at 9 a.m. If you have that paid off by then, it will then be canceled and you will not need to appear.
Okay, thank you.
Thank you. Anthony Bailey. The State of Ohio versus Anthony Bailey, CRB 25790, PRC 25301. It's like on the CRB 25790, you're just down to 12 hours of community service left, so 2 days. And on the PRC case, looks like you've wrapped it up. Looks like you're just down to 2 days community service to finish this.
Yes, sir.
Set you back for October 16th, 9 a.m. for review.
Thank you, sir.
If you haven't finished up by then, and the probation department lets you know that you're complete, then you don't have to appeal. Thank you.
Thank you.
John Benson II. John Benson II. State of Ohio versus John Benson II, PRC 2046 A&B. It was set for review this morning at 9 a.m. 9:52 a.m. He has failed to appear. That'll be a bench warrant to issue. Earl Carter.
Yes, sir.
This is State of Ohio versus Earl Carter, PRC 251974 A&B. All right, looks like this is from August 4th. So what's happened since then?
So since then, he has started to come to more groups regularly and doing individual sessions with case management team. Not to the fullest extent, but he is having transportation issues, but he is becoming more compliant. We're just working on those barriers, navigating them so that he can be there full term and be able to participate.
Okay. Do you guys offer transportation?
We do not typically. We were trying to figure out maybe a workaround to maybe see if like I could go pick him up or something like that. I've been talking to my supervisor to see if it's something that we could be able to do if able to be in our scope.
And also, sir, I did call them and I talked to a lady. She was supposed to come and get me. I waited and she never did come and get me.
Okay. So I will say this at this point, I'm not gonna hold that against you, Mr. Carter, at this point, if there are legitimate transportation issues. However, if you guys can't figure out something for him, you will need to refer him to someone that can pick him up, because we want to make sure that that's happening.
All right.
Otherwise, I'm going to reset you, Mr. Carter, back to October 16th for review at 9 a.m. And hopefully by then we'll have a better grasp on whether TPC can find a workaround and be able to make sure you're there, or if we can make a change for your well-being.
Yes, sir. Thank you.
Thank you. Tanner Collins. This is State of Ohio versus Tanner Collins, PRC 2612 ABMC. Mr. Collins, looks like you're down to $310 left.
I just put money on it yesterday. I have 100 that I can pay off directly after court.
Okay, well, I do see that there was a payment made yesterday, $202 cash payment.
Yeah, I got all the money to pay off the rest of it today.
Okay. Well, what I'll do is I'll go ahead and set it back for October 16th. That'll be a review at 9 a.m. That's all paid off at that point, and you're cleared through probation. Then you're not going to appear, and your case will be complete.
All right. Thank you.
Thank you. Hayden Curry. This is State of Ohio versus Hayden Curry, CRB 25789. And Mr. Curry, it looks like you've got everything paid off. You just owe community service.
Yes, sir.
When are you going to plan on start taking care of that?
Just as whenever I can get off work. I work 7 days a week, so it's really hard to get off work, but hopefully in the next 2 weeks I can get it killed out.
Well, let me ask you this. What type of schedule are you working?
5 a.m. to 7 p.m.
Okay. I'm sure if you talk with Mr. Cooper, they may have some evening opportunities that, I mean, it makes for a long day, but put yourself in a situation where you got to dig yourself out.
Yes, sir.
So I'll go ahead and set you back. You've made reasonable efforts towards payment of this, so I'll set you back for October 16th at 9 a.m.
Thank you.
Thank you. Christopher Dickerson. The State of Ohio versus Christopher Dickerson, CRB 26433. Okay, I've got a note here that Mr. Dickerson has not been compliant.
So I just recently
I want to speak to your treatment provider before I hear your stuff.
Yes, sir.
That is correct, Your Honor. So during the reporting period, in regards to that progress report, he was required 2 AOD sessions per week. Did not get his second one and received a non-compliance for that.
Okay. Is that the only non-compliance, as well as not doing eating or exercise requirements? Is that just for that one particular time, or is this an ongoing issue?
To my knowledge at this time, that was the only time.
All right.
If I may, Your Honor, I have since acquired a very good job. Work at Paving Solutions over in Huntington. So it's a pretty good life-changing job. So as far as like whatever fines and everything, I've been over this past week working out the kinks in my scheduling to make my treatment schedule collaborate with my work schedule. And I do believe that we have everything lined all the way up. So there will be no more non-compliances.
For your sake, Mr. Dickerson, I hope that is correct, because as of yet, other than your treatment, you've done nothing else on the case.
Yes, sir.
So, and while you're treating, I'm not going to hold that against you, but if you're not doing anything on the case and you're non-compliant with your treatment, then I have a problem.
Yes, sir.
So we'll treat this as a bump in the road. I'm not going to go out as far on this with you, because I want to make sure things are getting accomplished the way that they need to.
So I do work Monday through Friday, so anything as far as my weekends will be completely open for community service. If, we could line that up.
We do community service every Saturday.
Every Saturday, okay.
Let's do,
Could we get it for early October possibly? Just because I just started this job and I had to take off for today, and then, it would just be, I would really appreciate it
let's
to.
do October the 9th.
Awesome, yes, sir.
9 a.m. And I want to see a little bit better report next time.
Absolutely.
All right, thank you.
Thank you.
Thank you, Your Honor.
That's at 9 a.m. again?
Yes, sir. Cynthia Gannon. So State of Ohio versus Cynthia Gannon, CRB 25547. All right, very good report, Ms. Gannon. Looks like you're down to $150 left on the case, so you're working towards conclusion. I'm going to set you back for October 30th at 9 a.m.
Thank you.
Thank you.
Robin German, John Guido, Justin Hackworth, Gary Kazee, Buddy Malone Jr., Jared Stover, Alexis Smith, Ron Withdrawal.
Robin German. Robin German. All right, this is State of Ohio versus Robin German, 26860. Minor was set as a you failed to appear today. Yeah, bench warrant issued for failure to appear. John Guido. John Guido. State of Ohio versus John Guido, TRC 25944 A, B, and C. Guido is scheduled to be here at 9 a.m. Failed to appear, there will be a bench warrant issue. Justin Hackworth. State of Ohio versus Justin Hackworth, CRB 25765, CRB 24793, CRB 24267, CRB 14309. Good report. Set you back for October 30th.
Thank you, sir.
That'll be a review at 9 a.m.
All right, my friends, I'm afraid we've reached that time where I have to call it a week. But fear not, we will be back Monday, 9 a.m. Eastern, 6 a.m. Pacific, a half an hour earlier if you're a channel member. Plus, we'll probably post a video or two throughout the weekend, I would imagine. So keep your eyes on the channel, because we should have something for you. I'd be surprised if we didn't. My friends, thank you so much for spending your time with me this week. It has been a pleasure to have you here. Hope to see you all come Monday morning. In the meantime, go have yourselves a great weekend. Take care. God bless.